Good morning. This is Mike Carpenter, the Senate Chair of the Judiciary Committee. Just to let you know, we cannot begin until we have a quorum available in the chamber. We are short a couple of members at the moment, several of which are driving to our location. We hope to be back to you with a quorum shortly. Thank you. Good morning again. This is Mike Carpenter. Just want to let you know we're waiting on one more committee member to arrive to constitute a quorum. I understand she's in the parking lot and she will be here shortly. Good morning. Welcome to a work session by the Joint Standing Committee on the Judiciary. We're going to work three bills this morning: LD 2153, LD 2160, LR 2168, and three bills and an LR, and LD 2169, the infamous errors bill. Before we begin, I apologize to anybody tuning in that we were a little bit delayed by 35 minutes. We did not have a quorum. You have to have a quorum in the chamber to begin the meeting and to hold a vote. So I really appreciate the efforts of everybody. Representative Rachel Talbot Ross from Portland had other commitments, but she dropped those and drove up here from Portland, just arriving. Thank you, Rachel, very much. Otherwise, we would not be able to conduct business. Before I go any further, I would ask the committee members to introduce themselves, beginning with Representative Babbage, please.
Good morning. My name is Christopher Babbage. I represent House District 8, which is, and I reside in Kennebunk.
Good morning. I'm Shanna Bellows. I represent Senate District 14, 11 towns in southern Kennebec County.
Good morning and welcome. My name is Rachel Talbot Ross, and I represent House District 40, which is part of Portland.
Good morning, and thank you all for being here. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner.
Good morning, Representative Jeffrey Evangelos, House District 91. I reside in Friendship, and I need some tech help. I'm not able to log on yet. Thank you.
Good morning. My name is Donna Bailey. I represent House District 14, which is part of the wonderful city of Saco, and I'm the House Chair.
And once again, I'm Mike Carpenter, Senate District 2, Prescott to Patton. I'm the Senate Chair of the committee. So without any further ado, we're going to turn to LD 2153. And we're staffed by the incomparable Peggy Reinsch, who's going to come on here in a second and tell us what we should be doing. And Susan Panett is our committee clerk. Without the two of these women, we would not be able to function.
Thank you. Good morning, everybody. Thank you for your.
Peggy, now I'm going to have to hold you up for a second. While,
Oh, of course.
again, to explain the procedures, once, because of social distancing requirements, once we've established a quorum, several of our members then move to remote locations. Representative Babbage and Senator Bellows are now leaving the chamber. Our unwritten rule is that we won't discuss anything until they've arrived on scene at their various locations. So we'll just be a minute again, and then we should be off and running. Oh, Rachel, I'm sorry, Rachel, Representative Talbot Ross has had to go elsewhere as well.
Okay. She's going to stay here. Yes. Okay. Just let us know.
While we're waiting for the folks to arrive, I apologize. There are at least two committee members who are appearing remotely, and I've neglected to have them introduce themselves. It appears by the screen that I'm looking at, sorry, three members. So I would ask Representative Cardone, Representative DeVoe, and Representative Hagan in that order to introduce themselves, please. Oh, I'm sorry, and Representative Reckitt, my goodness, I'm failing this morning. Go ahead, Representative Cardone, are you there?
I am. I'm Barbara Cardone. I represent House District 127 in Bangor.
Representative John DeVoe, represent House District 149, Caribou, New Sweden, and Westmoreland.
Representative Hagan? You may be muted, David.
David Hagan.
Here we are. Thank you.
Hello, I'm David Hagan. I represent Hamden and Newburgh, House District 101. Thank you.
Representative Reckitt, I apologize for missing you.
That's right. My middle name is chopped liver, no problem. Anyway, my name is Lois Reckitt, and I'm the representative from the ocean end of South Portland, District 31. Thank you.
Thank you. Now back to Peggy.
Great, thank you. This bill was actually printed at the end of, just before you adjourned in March. It creates a new review panel to look at accidental drug overdoses. The composition is mostly experts as it's drafted. And you have in your file a chart comparing it with other review panels, and kind of pointed out that the things that are fairly consistent are the confidentiality of the records and the proceedings of these review panels. Their purpose is usually not to discipline anyone, but to figure out what went wrong with the system. It's the same with the child death and serious injury panel, the domestic homicide panel, and in some other panels. You had raised some questions at the public hearing for Gordon Smith, and he put together an amendment that I believe Supi has put in your file. And in addition, there were several concerns raised at the public hearing. And so he has brought in a whole panel of experts to try to answer your questions that you pose. So if you, maybe Gordon would like to go through the amendment, the proposed amendment. It's dated July 30th, or I can walk you through that, either way.
I'm happy to do it, Senator Carpenter. What would be your, I'd like to introduce my team as well. Could I do that?
Yes, go ahead, Gordon.
So with me, and I really appreciate them taking the time. I appreciate all the time of the committee members too on this bill. We have the Attorney General, Aaron Fry is with us. Notice he's in coat and tie. I'm feeling a little badly about that. We have the former Chief Medical Examiner for the state, Dr. Margaret Greenwald. Peggy still does some work for the state and might well be one of the people working with us on the panel. Dr. Marcella Sorg, our forensic anthropologist at the Margaret Chase Smith Center. Marcy has a contract with the Attorney General's office through the Chief Medical Examiner's office and does the overdose death reports. And Representative Talbot Ross was interested in a person in an expert in harm reduction. So I asked Kenny Miller from the Health Equity Alliance to join us this morning, and he's been able to do that. So thanks to that, my team. I'll take you quickly through the amendment. We've spent a lot of time on it this week. We tried to respond to each of the concerns that was raised by any committee member. I've tried to keep it simple. You have it in front of you, but I'll just go through the 4 sections quickly. We have retained what I had mentioned earlier that had not been done in the original bill by referencing the new name of the Office of Behavioral Health. That's in section 1. Also, there was concern about the unlimited number of appointments that the Attorney General and the Governor could have. So I've proposed simply deleting the language that said that the Attorney General and the Governor may each appoint additional members of the panel. And instead, we've added a person in recovery from a substance use disorder. That person would join the affected family member. I did make an error in drafting that I didn't put in an appointor of that person, but my intent was to have that person appointed by the Governor, as is the representative of family members. So those are the only changes in the composition, but we did go on to say, I've added language that the appointments will be made taking into consideration the racial and ethnic diversity of the state. If you wanted to go further, we could obviously say that the panel would review any racial and ethnic disparities in the data. We intend to do that. The data from the Chief Medical Examiner's office includes that element in any case. And but we wouldn't object to adding that if you felt that was important. In section 2, again, I mentioned this on Tuesday that we've changed the date of the first meeting because we're already beyond July 1st of 2020. Obviously, we'd like, if there's a session, if this bill gets on the governor's desk and signed, we would meet just as quickly as we could get the appointments done. But I felt that it was probably reasonable to put in a date of January 1st, 2021. I frankly hope that by then we would have met 3 or 4 times. In section 3, again, this was language that I talked about on Tuesday, but now we've put it in this proposed committee amendment specifying that we're really dealing with accidental drug overdoses and not overdoses that might be the result of a medical adventure or a misadventure in a healthcare setting. Those are reviewed as sentinel events by the entities themselves and licensing and certification. And on the very important question of the confidential criminal history, we've spent a lot of time on that. It turns out that I did get that language from one of the 5 existing death panels, so to speak, and it was it came from the Child Death and Serious Injury Review Panel, but that's also a panel that looks at suspicious child death and reviews the possibility of child abuse. And so while many of the people that I've talked to, including Commissioner Soschuk and others, believe that it would be helpful on occasion to have the confidential criminal history because it includes, for instance, arrests and not just convictions. If that's a problem for this committee, we don't want to hold up that bill. And I have proposed in this committee amendment simply deleting that language. I go on and delete the language regarding the public criminal history too, because obviously that is available to us anyway. So again, in the interest of responding to the committee's concerns, our feeling was until we get started, it would probably be quite rare that we would want that confidential criminal history. And if we find that that's really the inability to get it, that is really compromising our work, frankly, we'd come back next session and talk to you about that. So that's the amendment. All my team here is available to answer questions that you might have that came up on Tuesday. So thanks for your time and attention, and I'll turn it back to Senator Carpenter and Representative Bailey to see how you want to proceed from here.
Thank you, Mr. Smith. Are there any members of Mr. Smith's working group, for lack of a better term, that would like to augment his comments before I take questions? No? Seeing no hands. There are questions by members of the committee. Representative Talbot Ross.
Thank you, Mr. Chair. Hold on a second. And thank you, Mr. Smith, for that presentation. I'm getting a little feedback here. Yeah, it's on mute. Anyway. Thank you very much, and I appreciate everyone's patience this morning in getting started. I just had I want to also give thanks to the amendments that were made based on our last discussion about this with appreciation. It looks very good to me. I just had one quick question for you, Mr. Smith, and that is the use of the term substance use disorder in this bill, as opposed, which would incorporate, I believe, addiction to alcohol. So is there some reason why we're not using an opioid use disorder as opposed to the very broad definition of substance use disorder for this review panel? Because your scope is quite limited to the opioid response, trying to get a better response to that crisis. But substance use disorder actually includes other forms of substances other than opiates.
Thank you for your question, Representative Talbot Ross. I hadn't thought about that. The bill itself is intended to look at accidental death, overdose from drugs. Frequently, alcohol is in the mix, as Dr. Sorg could tell us. It's not really limited to opioids because, and we wouldn't want it to be, because right now, probably the fastest growing piece of that is the stimulants. Now the stimulants like meth and cocaine are also laced with fentanyl, which is an opioid. So it's complicated, but I probably would frankly prefer the broader term, just so that we can look at it at whatever has caused the overdose. Alcohol is frequently part of that mix. So while I didn't put a lot of thought into it, I think in thinking about it in the face of your question, I would I would prefer to use that term, but I'm going to ask Dr. Sorg if she wants to address that question. Or Dr. Greenwald.
Dr. Greenwald may want to have a few words here, but yes, Gordon's correct that most of the deaths, in fact, involve multiple drugs. It's almost always an opiate, but it's frequently other drugs as well, alcohol and increasingly stimulants these days. So individuals who end up in this situation are frequently involved with multiple drugs in their history. And it is really impossible to restrict it to just opioids.
Other comments? So, Gordon, you indicated that, and it seems to me this might be something we'd want to consider. You indicated that you probably wouldn't object if, as this panel is doing its work, if it noted disparities, for the lack of a better term, among various ethnic, racial groups, or I don't know whether you'd also want to say economic. I'm struggling a little bit with words. If there were, we know that there are significant disparities, for example, in the coronavirus death numbers among different ethnic and racial communities. And those have been well noted and well documented in all the stuff that we're learning about coronavirus deaths. I wonder, since you wouldn't object to putting this in here, if we were to include language to that effect under section 4.
I have no objection to that. I mentioned on Tuesday that there is we do collect data on the people that die with respect to race, and it shows some disparities, nothing like the COVID-19 issue. I don't think Marcy or the Attorney General would mind me saying what I said. I believe I said it on Tuesday, that I believe, for instance, that the Black population of the state represents about 1% of the state's population. They represent 2% of our fatal overdoses. Marcy will correct me if I'm wrong, but that's roughly the number. So I think it's important that you go into that recognizing that, yes, there are, and we'll undoubtedly find discrepancies, disparities with based upon economics. Senator Carpenter, I'd have to again ask people like the Attorney General and Dr. Sorg and Dr. Greenwald whether it would create any problems if in section 4 we put the panel would review any for the cases that are selected, any racial, ethnic, or economic disparity.
Well, let me interrupt you. If you're already collecting that data, maybe we don't need to do it a second time. I'd forgotten, but I remember now that you said the 1% or 2% on Wednesday, so maybe we don't need to put that in there since it's already being collected by your office.
Being collected by the office of the chief medical examiner, and
okay,
through their reporting to the University of Maine, it gets in the reports.
So the data would be there if you or any other group wanted to go look for it.
It is there.
Okay, thank you. Disregard. Okay.
Senator Carpenter, may I expand on this question for a minute?
Sure. Go ahead.
Mr. Smith, is it possible, taking a slightly different route? I think it's really important. Sometimes these disparities are here, but if no one looks at them, or if the deaths that are reviewed happen to be all white deaths, then we don't, and this is a longstanding historic problem in the medical field, and that is that the focus of study and research tends to be predominantly white focused. So I wondered if we might amend 4 to just say the panel shall examine a subset of the deaths associated with accidental drug overdoses, taking into account the racial and ethnic composition of those deaths, or something that directs specifically that that subset shall be, or a subset that is representative of the racial and ethnic composition of the accidental drug overdose deaths in the state, so that you're not inadvertently just looking at white overdose deaths, even if the rate among Black Mainers is only 2%, it's still really important to look at. So I just wondered if there's a different way, not to require the panel necessarily to look at disparities, although that would be, I think that would be wonderful, but just to try to create some language that ensures that it's the responsibility of the panel to be looking at a subset that is in fact representative of the racial and ethnic composition of the data itself.
I have no objection to that. I do want to see if Dr. Sorg or the Attorney General or Dr. Greenwald have any problem with that. As you know, we don't have the resources to look at every death.
Right.
However, we would clearly have the resources to, in addition to looking at the cases that would be brought to us from the Chief Medical Examiner's office, it would be relatively easy to say that we would look at any death that of racial minorities in the state, and particularly Native Americans as well as Black population. Much as we look at the homeless population, Dr. Sorg and her team do an incredible job. And now, as I mentioned to you, we see the data. I see the data every week. I don't know about, we might ask Dr. Sorg to address the issue of the economic disparities. I don't know, frankly, if in the regular work that's done by the medical examiner's office, whether they would normally be seeking out, have information on that issue. So I'd ask Marcy to address that, and then the Attorney General.
Yes, we don't normally collect that as a data point, the economic issues. Those are available in the sense of looking at census blocks and areas where people live. They are available in looking at census information and income levels in the census records, but the medical examiner doesn't collect data like that. And I think Dr. Greenwald might want to chime in here just to clarify.
We have the location, of course, of an individual person's death when we are collecting information, but we haven't anyway looked at that in terms of the data collection by, as Dr. Sorg said, the Census Bureau set up for the economics of a particular region. So it's possible, but it certainly would take a lot more work to collate that data. Trying to make sure that we include the particular racial or ethnic composition, I think would be fairly easy, but the economic one would be a little more difficult.
Representative Bailey.
It's a totally different question that was raised to me. The new person in recovery from substance use disorder, does there need to be an appointing authority for that person?
Yes, I had intended to mention it if I didn't, that I neglected to include that in that subsection N, and I intended to have it appointed by the governor because that the governor is also appointing the representative of family, affected family members, but absolutely that needs to be added. Otherwise it would just be hanging there. So thank you for pointing that out. We
Other
didn't give
questions,
the Attorney General,
comments? Go ahead.
Governor, we didn't give the Attorney General a chance to address whether he sees any problems with the racial, ethnic, or economic piece of this.
Attorney General Fry, you want to weigh in?
Yes, thank you, Senator. Good morning, Aaron Fry, Maine Attorney General. No, I think, and I believe this goes to what Senator Bellows was touching upon. It probably would be not a bad idea to ensure that there is a clear directive to take a look at this information. I mean, the fact that it's collected is certainly one thing, but if folks aren't thinking to look at it through a certain with a certain perspective or with a certain focus, then there'll always be a question of whether or not that focus is being considered or those factors are being considered. So I guess to the extent that it is important to look at these disparate impacts, and there may be a way to build that into either paragraph 4 or make it more clear in language about ensuring that there's membership that reflects the racial and ethnic backgrounds in the state. I think probably that would be a positive addition to this proposal.
Thank you, Attorney General Fry. Any questions, members of the committee? So Peggy, where's Peggy? Uh-oh. Peggy's been, there's Peggy. Why am I echoing?
You have,
There
somebody's
you go.
microphone is on.
That's me.
Okay.
So do you think you have enough information for drafting purposes?
Well, I don't think it sounded like you were not going to ask for a specific review of the data, the racial, ethnic, or economic data. Is that correct?
I think so. I don't, unless
Okay.
somebody wants to.
So I think
I'm sorry.
Mr. Smith's amendment is what you talked about, other than adding the appointing authority for paragraph N.
Senator Bellows?
So if
Okay, right.
if a motion is in order, or if Peggy is able, I loved Mr. Smith's amendment with the additions that we've talked about today in terms of the appointing authority, but also adding a phrase in subsection 4 of the original bill that, or section 4 of the original bill, that says the panel shall examine a subset of the deaths associated with accidental drug overdoses, taking into account the racial and ethnic composition of the data, or something to that effect. That's what I thought we were talking about. So we weren't asking them, so we're asking to make sure that the subset of deaths that is examined is taking into account the racial and ethnic composition. Does that make sense to everybody? I see some head nodding.
So I'm going to take that in the form of a motion to amend the amendment. Do I have a second? Representative Bailey seconds it. So we're going to amend the bill in subsection 4 because we don't do much with subsection 4 in the, okay, so the motion is to amend the amendment as was proposed to us today, and to come up with a new amendment. Everybody clear on what we're going to do? All right, so I would request that the remote members of my committee return to the chamber, the House chamber, so we can vote. And we'll be on pause until they come back. And then we will move to vote on the bill as amended. And we will review the language whatever day we come in next week, Friday or Thursday or whatever.
Or I can email it to you too, and then you can talk about it if you have concerns.
Thank you. The legislative process is slow and cumbersome enough on a good day, and it's, please bear with us. It's even slower this way. especially when one of our members has to come on a hoverboard.
Well, and just to ice our cake, I'm having computer problems of my own here in my office. So that's why Rick was here trying to fix it while you were talking. And it's not repaired yet, so maybe we can do it at a break.
All right, all 7 present members are present. So I would ask for a show of hands, and the motion is to amend the amendment in section 4, which is also section 4 of the bill, to include the language that Senator Bellows, and I don't, if anybody wants it read back, we can. If not, I'd ask for a show of hands in support of the amendment. Pardon?
Also the appointing authority.
Oh, yeah, I'm sorry. And also the appointing authority, Peggy. I'm sorry. I was just reminded of that. Thank you. All opposed? All right, so the people who are up, who I've forgotten already, who are remote from the State House, you'll have 24 hours to contact your presiding officer, the Speaker, or the Senate President to indicate your support. So now I'm looking for a motion on the bill as amended. Moved by Representative Babbage, seconded by Representative Bailey. Any discussion? All in favor of the motion? Oh, this should probably by the call. So I'd ask the clerk to call the roll, please. To pass as amended. Go ahead.
Representative Cardone. Representative Cardone is absent. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Curtis. Representative Curtis is absent. Representative Reckitt. Representative Reckitt is absent. Senator Bellows.
Yes.
Senator Bellows votes yes. Senator Carpenter.
Yes.
Senator Carpenter votes yes. Representative Bailey.
Yes.
Representative Bailey votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Talbot Ross.
Yes.
Representative Talbot Ross votes yes. Representative DeVoe. Representative DeVoe is absent. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. 7 members voting yes.
7 members voting in the affirmative and no members in the negative. The motion ought to pass as amended prevails. Thank you.
Thank you all. Thank you all, my team. I appreciate it.
Before we lose our remote members, I just want to remind the committee we will need to do a freedom of access review on this bill.
Do you want to do that now?
I can do it now, or I can wait for the language from Peggy and circulate an email memo as we have done with the other bills.
Okay. All right, we'll wait for.
Oh, wait, I don't do a memo. Don't wait for me.
Okay, we'll wait for you. We'll wait for the final language.
That's fine.
All right. We'll have to do a freedom of access review of this bill. Thank you.
Thank you.
LD 2160 is the next one we're going to take up. Act relating to the statute of limitations for injuries or harm resulting from chemicals. As good as it's going to get. Peggy, oh, that's right, too. We have to wait for our members to get back. Thank
All right.
you. Representative Bailey for keeping me straight.
Thank you for that.
Oh. Okay, we're all there. All right, Peggy, go ahead.
Great, thank you. So this bill, again, was printed at the end of the session, but you just heard it on Tuesday. And what it does is applies a discovery rule for for actions arising out of any harm or injury caused by perfluoroalkyl or polyfluoroalkyl substance. Right now, the current statute of limitations is 6 years for general tort law, general tort claims, civil claims. This without a discovery rule, and the case would accrue, the claim would accrue at the act or omission of whoever caused the injury. With these chemicals, you might not know when that occurred. You'd only know when the harm is actually discovered. And so what this bill does is it says that statute of limitations doesn't run until, it doesn't start running until the plaintiff discovers or reasonably should have discovered that the harm or the injury has occurred. And so that would be, so it moves the starting time of the 6 years for the statute of limitations. You had a fair amount of written testimony, and Representative Ingwerson is here, and he has proposed an amendment. If you remember, there was somebody speaking about the Maine Tort Claims Act, and he sent an amendment to my email, which you have a copy of in your file. Nothing in this section shall be construed to alter the separate notice period applicable to governmental entities contained under the Maine Tort Claims Act, which I think we've changed to 18 months. I'm trying to remember. Or the time to bring forth an action contained in the Maine Tort Claims Act, which is 2 years. The statute of limitations is 2 years under the Maine Tort Claims Act. And Bruce Garrity and Charlie Sultan, representing insurance companies, also put together an amendment to change it to 2 years and limits this discovery statute of limitations to when the defendant is a manufacturer of the substance. And you did receive some more written testimony after the public hearing, including Mr. Garrity did respond and provide written testimony for you.
Thank you, Peggy. So we have 2 proposed amendments to the bill. We're going to take them separately.
Yes.
Representative Ingwerson you all should have an email in your file proposing to, as Peggy indicated, to make very clear we're not altering the notice provision or notice period applicable to the Maine Tort Claims Act or the time to bring forth an action. Peggy, I had a call and I looked at the Tort Claims Act this morning, 8102. The issue of municipal water districts, sanitary districts is pretty clear. I don't know if there has been any litigation around that. I don't think there's any question that municipal water districts are excluded under the tort from suit under the Tort Claims Act. None that I'm aware of. Are you aware of any?
I'm not. I did not look at that question though.
If you'd look at 8102.
Yep.
That
right.
Got it. So
yeah. So political subdivision specifically includes any authority created by statute, a quasi-municipal corporation and special purpose district, including but not limited to any water district, sanitary district, hospital district, school district. So that would include the water utilities and the sewer utilities.
It would not, however, exclude private water districts if there are such things. Am I correct?
Right. I wouldn't think that, right, the Tort Claims Act would be expected to extend to the private, any kind of private utility.
That's what I thought, but I needed reassurance from you. Thank you. Other questions or comments by committee members with regard to the proposal by Representative Ingerson? Representative Ingerson, did you have anything you wanted to add?
No, I'm fine with the amendment. I hemmed and hawed a little bit about it was even necessary, because to me, it seems like it's more than a footnote, more like a footnote in the bill, since the Maine Tort Claims Act is pretty clear in its exemptions and pretty clear that quasi municipalities and sewer districts and water districts automatically are considered under that act. And this change that we're making would not be applicable to them. So leaving it out is also fine, but I'm not going to be wishy-washy about it. I'll say that it's good to have it in there more as a reference. So that's about all I have to say about it.
I have talked to a couple of representatives from water districts since Wednesday, and it seems to me, out of an abundance of caution, they also carry insurance. So this will increase the cost of their insurance. Even though we're not changing the liability issue, we are potentially changing the length of time in which an action could be brought. So I'm sure that they're going to see an increase in their insurance rates, but that's as it is. Are there other questions or comments by members of the committee? Representative Cardone.
I do have my hand raised electronically. Are you monitoring that, or should we be doing it visually?
It was unintentional. I apologize. Go ahead.
Okay. My comment was originally directed to the second proposed amendment, but since you brought it up regarding water districts and insurance, I think it's relevant to this as well. As I understand the intent of this bill, it is to really get at the manufacturers and to make the manufacturers liable for the damage, even though it's going to be more than 6 years. So we need to expand our statute of limitations. I think we ought to consider limiting this expanded statute of limitations to manufacturers. And that's what this second amendment does. And it also contracts the scope of the expansion to 2 years from the date of discovery, but that's a different issue as far as I'm concerned. But limiting this to manufacturers keeps the manufacturers liable for a certain number of years, whatever we decide from the date of discovery. But what it doesn't do is keep the little guys on the hook and price out, make the cost of insurance for them skyrocket or perhaps even be impossible to get. And I'm concerned about not only the water districts, private water districts that you mentioned, but even people in
print and sign. That's Donna's. Oh, not a problem. You need sign where you're, there you go.
Senator Bellows, would you turn your mic off?
Oh, forgive me.
Go ahead, Representative Cardone.
Even people in the chain of title, or somebody, if we're talking about sludge, somebody who's handled this sludge, transported it, made the decision to put it on the land. I think there are a lot of people there who are unintentionally on the hook for a long period of time, for whom insurance is going to be either impossible to get or at least at a much higher price. And I don't think that's what we're intending to do with this act. I don't think that was Mr. Ingerson can speak to it, and Ms. Fay, if she's on the line, but I think the intention really was to keep the manufacturers on the hook. And so I'd like to see this whittled down to focusing on liability for the manufacturers and expanding this statute of limitations.
There's a proposed amendment. That's the second amendment.
That's right.
If you don't mind, let's hold off on that issue till we get beyond the proposed amendment put forth by Representative Ingerson, and then we'll get to that. I mean, that's That's a significant suggestion. Are there other comments at this point on Representative Ingerson's proposal for clarifying language on notice? Do I have a motion to, Representative Harnett, you move to amend the bill?
To amend to include the language suggested by Representative Ingerson.
Do I have a second for that? Representative Evangelos, moved by Representative Harnett, seconded by Representative Evangelos, that we would amend Representative Ingerson's proposal with the language he contained in the email of July 30th. Any questions? Senator Bellows, did you have a question on that piece?
My question was regarding the second amendment that's been proposed. So on that piece,
We'll get
I
to
agree with Representative Ingerson that's not necessary, but I'm willing to go along with it and support it.
What I would propose to do is, since we have two amendments we're going to consider, we're now going to move to the second proposal, the one that Representative Cardone was talking about. We'll discuss that, and then that way we don't have to have people running back and forth in the hallways to come down here. So I want everybody sit tight for now. We're now going to take up the second amendment proposed by Representative Cardone, which he just discussed, and which we have a copy of in our file also, which would limit, it would create a discovery rule, but a discovery rule of only 2 years. Also, and make it very clear, an action brought into the section shall be limited to the manufacturer of a chlorofluoric, or whatever. Bad chemical, we'll call it, okay? We just put bad chemical in the statute. Representative Cardone, did you want to offer anything else, or are you okay for now?
I would ask that Mr. Sultan and Mr. Garrity, who I think are both on this call, be allowed to speak if they wish to do so. I didn't really much address the 2 years or that is a separate issue from who we're holding liable from the discovery rule. But if either of those folks have anything to say about this, I'd like them to have the opportunity to do so.
So before I invite, and I'll invite Mr. Sultan on, before I go there, I guess the question I would have would be, why would we not want to hold responsible at least the distributors of these chemicals? So you'd say the manufacturer, who may be hard to reach, that's who we really want. But then you have to distribute these chemicals. And if the distributor is aware of their harmful properties, why would we exempt them? It's just a question. Mr. Sultan, do you have any thoughts on that?
Thank you, Senator Carpenter. I have no idea how these chemicals are distributed or what that means. Does that mean that the water utility is a distributor because the chemicals within the sludge that they distributed to the farmer, or some intermediary that transports simply the raw material, the chemical, whatever, to a manufacturer that incorporates it within a product for sale or use in some other form. So I'm not entirely clear what or how that would work, or who those folks are, or what role they had other than being a trucker, a train freight operator or something like that would have. So I guess that would be my question there.
Well, I'm assuming we can find a definition of distributor in the statute. I'm clearly not intending the truck driver or the train operator to be. Representative Bailey, go ahead.
I would just remind everyone that, again, the intention of this bill is very narrow, which is to change the statute of limitations. The intention of this bill and what the public hearing was on is not talking about liability. So I'm not interested in changing liability. Liability is what it is, and the courts can sift through that, and the courts know who's liable, who's negligent, how far the chain down the chain. If we want to change liability, if we want to look at liability, I think that's another bill for another day. So I'm concerned that we're going down this rabbit hole looking at liability when, again, the question of the bill is simply one of looking at the statute of limitations. Thank you.
That's a very good point, and that was what the public hearing was about. It was only about the statute of limitations issue. Mr. Garrity, do you want to weigh in?
Yeah, I appreciate that, Senator. We recognize that's the scope of the bill, and we did propose an amendment for your consideration, recognizing that there did appear to be some significant interest in the legislation. And again, in that amendment, we tried to stick to the scope of the legislation dealing with statute of limitations.
Well, except that your proposal also limits it to exclusively to manufacturers. So I think that was Representative Bailey's point. I have Representative Harnett.
Thank you, Mr. Chair. Are we discussing the change from 6 to 2 years now, or should I hold off on that until?
No, we're discussing everything in that amendment, which has two parts.
I'm opposed to that change, but I would like to hear from Professor Faber. I know he circulated a memo to us. I don't have a hard copy in my file about how this is handled in other states. There are some states that just have a pure discovery rule with no limitation. Main standard civil statute of limitation is 6 years. I don't see a reason here to change that from 6 until 2, even though the trigger is now discovery. I think it should be treated as are all other civil torts. But I would like to hear from Professor Faber.
I believe Professor Faber is still on the call. He was. Professor Faber, you want to join us?
Yeah,
there you are.
Thank you for the question.
Welcome.
That's correct. That many states have discovery rules, and the amount of time that is permitted for an action after the plaintiff has discovered the harm varies. It's varies from 1 to 2 years in some states, and can go as long as 5 or 6 years in other states like Missouri and North Dakota. So the model that Representative Ingerson is proposing, which would be to retain the 6-year statute of limitations that Maine has now, but to add a discovery rule, is similar to the statutes in some other states. And that's particularly true. And there are a number of states that have, in particular, considered these sorts of harms from the release of toxic pollutants that have caused property damages, and have found that a discovery rule was appropriate in part because the landowner is often unaware of these damages for many years.
Do you want to comment also on the proposal to limit the liability? Although I respect Representative Bailey's point. While I have you on mic, I thought I might ask you to comment about other states. Is there much of a way of a limitation on to only manufacturers, or they let the court sort that out?
Senator, I have not looked into how other states have treated the liability of other parties. I'm happy to do that for you today and get back to you as quickly as I can.
I doubt that it will be necessary. Thank you. Representative Cardone, this time I saw your hand.
I have to make the point that I disagree with Representative Bailey and the distinction that she's made, because as soon as you start changing the statute of limitations, you are invoking the issue of liability and expanding liability. And here we can deal with the issue of liability or not expanding liability beyond the 6 years that we have by simply limiting who the statute of limitations applies to. So I think these two things are intrinsically linked together And we can't simply say it's a statute of limitations issue. It's not a liability issue. Because in fact, as we know, in tort claims in Maine, it's joint and several liability. So if you expand the statute of limitations from 6 years from the date of discovery for everyone, you're automatically invoking joint and several liability for all parties, which means generally that the plaintiff sues everybody in sight, and then the defendants are left to have it sorted out by cross claims or apportionment of liability. What that doesn't do is protect the other defendants, the little guys, from actually being sued. So they're going to incur costs, defense costs. They may well incur liability costs depending on how apportionment gets decided by the jury. And with these possibilities comes the increase in costs for insurance. And that's what concerns me, the insurance for the little guys, for people unknowingly or unwillingly passing these chemicals or making decisions that somehow involve these chemicals, but they're not even aware of that. That's where my concern lies here. And I don't think you can just say that's a liability issue. It's not a statute of limitations issue, because by changing the statute of limitations, we are going to affect insurance premiums or even the possibility of getting insurance.
Other questions? Senator Bellows.
Thank you. So just to respond to that, I would like to express concerns that this amendment is just to the manufacturers of the chemicals themselves. But what we learned in the testimony and what I'm hearing from constituents are concerns about companies and industries that utilize these chemicals in their industrial processes and in the making of their own products. And it was astonishing and concerning to learn about the nature and extent of utilization of these chemicals in cosmetics and personal care products. We know in Maine, we've had ongoing issues with tanneries, in earlier years, the paper mills. And so I think to narrowly tailor this just to the manufacturers of the chemicals themselves, when in terms of little guys, you know, we were hearing from a dairy farmer. There's another central Maine dairy farmer who's just had their livelihood eviscerated by discovery of this contamination. I have been receiving complaints from constituents who do small-scale farming in West Gardner about the placement of the liquid sludge on their fields and the potential neighboring fields and the potential ramifications. So I think I'll be opposing this amendment. I think that it is too narrowly constrained and undermines the goal. And in terms of little guys, I'm deeply alarmed that our small farmers in Maine, that this is just the beginning of a huge problem that we have. And in terms of 2 years versus 6 years, I have a lot of concerns, again, given what we heard in the hearing about how the data and evidence about the harmfulness of this was hidden for so long. If we restrict it to 2 years, given the challenges of diagnosing a problem, in researching and trying to get information, I think that that is entirely too short. So I will be supporting the original bill as amended by the sponsor. I can't go down this road. And I just wanted to recognize I'm fortunate to have constituents from both sides in this work session and in the hearing, but I see that the Honorable Sharon Treat, who testified in the hearing, has joined us as well. She's one of my predecessors, and I didn't know if she wanted to comment on the proposed amendment in terms of narrowing the statute of limitations to 2 years and in terms of limiting liability only to the manufacturers of the chemicals themselves.
Senator Treat has her hand up, and she's next. Welcome.
Great, thank you. And I hadn't really figured out how to do this whole Zoom work session, so I'm sorry I missed a lot of what has already taken place. I would like to say something about this amendment. I have two concerns about both aspects of it. And just as some background, I mean, in addition to being a state senator, I actually taught toxic tort law at Maine Law School for a number of years and actually did litigation around hazardous waste sites in many years past. So I have some familiarity with these issues. And my concerns are twofold. First of all, the short period of time. I understand, I could see how you might want to do something like that since it's changing, to this discovery rule. But in fact, these kinds of cases are very complicated cases. They involve multiple records. I mean, just look at what the PFAS task force did. It took them 6 months to try to track down their own records about sewage sludge spreading sites around the state of Maine, when they still haven't tested any of those. We don't know where the paper mill records are. There's some rumors about a lot of that went into some of these southern Maine sewage treatment plants. As Senator Bellows mentioned, you've got the health issues. So if someone is trying to sue based on the harm to their property, as well as to their livelihoods, as well as to their health, there are those kinds of issues which are very complicated. And again, as Senator Bellows mentioned, here we have a situation, and it's often the case with chemical litigation, but it's a situation where you have the manufacturers and others that have control over these records, and it's going to be on the plaintiff to try to figure out how to get those records and to give you a 2-year time frame to kind of pull your whole case together to file it from the time when you first discovered that something bad was going on there. I don't think it makes a lot of sense. I mean, a simple slip and fall case, you get 6 years. And what do you have to figure out there? Not that much. This is coming from the insurance companies. It's about, protecting them. It's not about protecting small guys. There's plenty of things that insurance companies have to, insure against. And it's understandable that they would rather get out of that liability, but I don't think that it's a very strong case for them here. There's lots of other things that you wouldn't do that for. And then on the issue of, limiting to manufacturers, again, we're still finding out who has responsibility for these things. But if you're inclined to come up with some kind of exemption because you're worried about, POTWs, municipal plants or something, you can come up with a narrow exemption without doing the opposite, which is what this amendment does, which is to limit any and all cases into the future relating to PFAS, basically, or at least the statute of limitations relating to that, to manufacturers. It also would create some confusion. So does that mean that only, is this the only statute of limitation that applies to PFAS? So if you had a PFAS case that went against somebody else, it would have a different statute of limitation. I mean, I don't know, but I don't think we should be limiting lawsuits to one party when we don't actually know right now who might be responsible ultimately for some of these things. So, I think, and just one last thing, I mean, if you look at what other states have done, there are states that have long periods for statutes of limitations as well as the discovery rule. They're not mutually exclusive. So, it just doesn't make sense to me.
Thank you. Representative Babbage, need your hand up.
Thank you, Mr. Chairman. First of all, I want to apologize to the sponsor. I think I got the second amendment in the mail, and knowing that Representative Ingerson had an amendment, I thought it was his. And so I replied to him and said, you've compromised more than you needed to in order to get my vote, but I certainly will vote for what you want to propose. So yes, I could vote for it if the sponsor wants this, but I have to tell you, I think the 6 years is fine. And I'm probably still, even though I got some help and I'm very thankful for it, still not real clear on the extent of tort law protection. My thinking was that you know, the ratepayers should be protected, but that there should be recourse when there's been some threshold of negligence. And I don't know to what capacity that currently is possible. But I am just communicating to the sponsor that I am on board with his amendment. Thank you.
I think we are, we voted on the amendment proposed by the sponsor. This is this, I'm sorry.
Right.
No, we haven't, I'm sorry, no, we haven't, we stepped aside from that one to do this. That way I didn't have to make you come here twice. So now we're considering the second amendment as was proposed by Representative Cardone. I see Mr. Soltan has his hand up. Go ahead, Mr. Soltan.
Thank you, Senator. Just a couple of points real quick. I believe it was Professor Faber's memo that was distributed that talked about the different states. And so just FYI, Connecticut limited their discovery rule to 2 years. Rhode Island limits it to manufacturers. So those are New England sister states that give examples to why they are there. And I think we have our own statutes in Maine that use a discovery rule, for example, in medical malpractice, that have a shorter time period, in part because of the medical construct we have, but also because the discovery rule tends to extend the statute of limitations. And if you have knowledge, then they give you generally a tighter time frame. I think the more important point I'd like to make is that if you leave the statute as it is, the farmers are going to be liable as well in a lawsuit. You're not protecting them at all from people who consumed, use their products. And so they are going to be just as liable as the manufacturer. And that is why listening to the hearing and listening to the testimony and reading the letter of Berman Simmons, it was clearly targeted at manufacturers. And that's why we drafted the memo as it is. If there is when there's more time to discuss this issue and PFAS generally, which obviously is a big concern, then you can go back and change it later. But that's how we and why we limited it the way we did.
Thank you, Mr. Soltan. Any further comments or questions? If not, Senator Bellows?
I have two questions, Senator Carper, with indulgence. The first I want to just explore, is the sponsor supporting the narrowing of the statute of limitations to 2 years and the restriction just to the actual manufacturers of the chemicals themselves?
I'll let him weigh in. I don't think so. Mr. Representative Ingerson?
Absolutely not. I feel, first of all, that only pointing at manufacturers really brings us into the whole issue of liability. And it's really interesting that we've been going around about who will be liable and who's not, but that's really not for us to decide. For us to decide is the simple narrow piece of this law, which changes that definition from accrual to discovery of harm. I find this discussion interesting, but I also, as many of you know, that it's for the courts to decide who's liable and who's not. And that's an exploration that's really worthy of having. But the small farmers who are not liable, by the way, they need an opportunity to have their day in court so that we can do fact finding, such as we're discussing now, actually. So no, I don't agree with either making it narrowly to manufacturers or shortening the length of time at all.
Thank you, Representative Ingerson. Senator Bellows, you want to continue, and then Representative Babbage, I'll come to you.
Representative Ingerson answered both my questions for now. So go ahead,
sure.
Representative Babbage.
I'm sure it's only for now. Thank you. Representative Babbage, please. Go ahead.
Oh, yes. Thank you. I'm on, right? You can hear me? I do appreciate Senator Bellows because she makes me look good sometimes. She is. I guess I just wanted clarification. I thought what the sponsor just said was very appropriate. But for clarification, can somebody tell me, according to tort law in the state of Maine right now, then what is the level of liability to water and sewer districts? Can anybody clarify that? Yes, go ahead. Oh, well, I'm sorry.
I'm not a lawyer, but I'm hoping there's maybe other lawyers in the room, in the virtual room, that can clarify. But I can say that what I do have here in front of me is that the Maine Tort Claims Act automatically kicks in when municipalities, quasi-municipalities, sewer and water districts, all as defined under the Maine Tort Claims Act. They apply to all those groups. And I think there's more detail than that. And there's 2 layers of protection for them as well, already in law. There's a 365-day notice requirement under section 8107. The exceptions for good cause have been very narrowly interpreted by the court. Additionally, an action, quote, must be commenced within 2 years after the cause of action accrues. Emphasis added to section 88110. The law regarding statute of limitations for civil cases, which this bill that we're proposing adjust, does not apply to government entities, including water and sewer districts, because any claims brought against them would fall under the Maine Tort Claims Act. So that's a bit of what I do know. I don't know if that helped you, Chris.
Thank you. I guess then I have read that, Henry, but I'm trying to determine if that means that a sewer district knowingly sells sludge to a farmer who spreads it on his field, knowingly with an identified hazardous chemical in it, that the Tort Claims Act still protects the sewer district? Is that what that means?
I mean, believe it would.
Okay, thank you. That's.
Other questions? Representative Cardone.
Just as a follow-up on that, that would not be true if the water and sewer district has insurance. There's an insurance waiver in the Maine Tort Claims Act. So even though the statute of limitations issue that we're talking about wouldn't apply, the liability may still be there if in fact there's insurance to cover the negligence or whatever the claim is.
Other questions? Mr. Garrity, you had your hand up.
Thank you, Senator. The only other point I was going to make is, to the extent we're talking about entities such as fire departments, they're knowingly using these chemicals to help put out a fire. Now, they're not doing it negligently. They're not doing it inappropriately, so to speak, but they're going to be in the same boat, assuming there's insurance coverage. Thank you.
Fire departments, you are exempted the same way as water districts, am I correct?
Yes,
except for insurance.
Exactly, except for the insurance that brings them in. And I think respectfully, Senator, that brings up the question of how difficult might it be in the future to secure coverage if they're going to be out there and have some exposure, at least under a policy.
Thank you. Senator Bellows?
Just to, again, and maybe to go to the Honorable Sharon Treat, or maybe Representative Bailey can help with this again. But what the issue we're addressing, though, is when someone can bring suit, not what kind of suit that they can bring. It's just the deadline for filing based on realizing or experiencing the harm that something happened.
That's correct.
Am I correct? Am I misunderstanding that? Okay.
May I ask?
Sorry.
Yeah, for just
I answered it even though you didn't ask me to.
Thank you, Senator Carpenter.
Professor Faber, go ahead.
Just a sort of a quick observation, and Senator Treat mentioned this as well, that a number of states have statutes of limitations that are 5 or 6 years and have discovery rules. So, but I think more importantly, if you said a farmer who has been harmed because of the application of sludge would only have 2 years, you would be creating an inequity where everyone else in Maine who's been harmed, whose property had been harmed, would have 6 years from the point from which they knew they'd been harmed to bring a case, bring an action. But farmers who've been impacted by PFAS pollution would only have 2 years to pull together, as Senator Treat mentioned, extraordinarily complicated cases. So I don't think your intent would be to create an unfair playing field where farmers who've been harmed by no fault of their own would have less time to put together a case than any other injured party in the state of Maine. And I think that would be not the result you're seeking.
Thank you. Representative Harnett.
Thank you, Mr. Chair. I agree with Representative Bailey's point from quite a while ago that this is about a statute of limitations, period. Right now, I mean, all these other issues that are being raised, who's going to be liable, who's possibly going to be named as a defendant, they all exist right now in cases that may have fit under the 6-year statute of limitations already. You know, there may have been cases where people were aware of the harm within that period and brought a lawsuit. Issues of liability are sorted out by the courts. This is a legislative determination only about what is the statute of limitations. All of the problems that are being discussed already exist. They're not for us to resolve here.
Thank you. Questions, comments? If not, I would ask the committee members present in the building to make their way down here, please. We'll wait until you get here. We're still trying to retrieve committee members. We've lost a committee member, but we're in the process of finding her. For some reason, I've been bounced off the meeting here, but I guess everybody can still hear me. All right, we have now 7 members. We reconstituted the quorum in the House chamber. The only pending motion before the committee at this point is the motion to adopt Representative Ingerson's amendment, which has to do with the notice provisions of the Maine Tort Claims Act. Is everybody clear? And that has been moved and seconded. Is everybody clear on that? Any comments or questions about that? All in favor, please so indicate. All opposed? I believe it is 7 in favor and none opposed. That amendment is adopted. Now, we also had a discussion about the second amendment as was proposed by Representative Cardone. I do not have a motion at this point. Is there anybody present in the chamber who wishes to move adoption of that motion? I see no indication. That will not be considered. Now, the pending motion, I'm looking for a motion. Representative Bailey.
Thank you, Mr. Chair. I move ought to pass as amended.
Moved by Representative Bailey, seconded by Representative Harnett to my screen is doing things here and distracting me, to move the bill ought to pass as amended with Representative Ingerson's amendment only. Discussion? Committee clerk would please call the roll.
Representative Cardone. Representative Cardone is absent. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Curtis. Representative Curtis is absent. Representative Reckett. Representative Reckett is absent. Senator Bellows.
Yes.
Senator Bellows votes yes. Senator Carpenter.
Yes.
Senator Carpenter votes yes. Representative Bailey.
Yes.
Representative Bailey votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Talbot Ross.
Yes.
Representative Talbot Ross votes yes. Representative DeVoe. Representative DeVoe is absent. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. 7 members voting in the affirmative.
7 members voting in the affirmative, none in the negative. The motion ought to pass as amended does prevail. Members who are remote will have 24 hours to contact the either the Speaker's office or the Senate President's office. We're going to move to LR 2168 and act to implement the Attorney General's recommendations on data collection in order to eliminate profiling in Maine.
If it is now LR 3334 is now LD 2168, and Representative Hickman asked me to give him a call. He's in the building working with the VLA committee. So if you can give me 2 seconds to give him a call. I think other people have to get back to their seats anyway.
That's correct.
So
I keep forgetting that part. You go ahead.
thanks.
I'm not trying to.
No, I know it's hard.
Keep forgetting. All right. I'm going to.
So everyone seems to be back in their remote locations, and Representative Hickman is on. So Peggy.
So you had before you on Tuesday LR 3334, and it has now been printed and given an LD number, and it's LD 2168. The text is still the same. It is a concept draft to adopt, to put into law the recommendations from the Attorney General's report that he submitted, that was required from Representative Hickman's bill that passed in the first session, LD 1475, which is now chapter 410. And I think you have that in your file. You have the report, you have the original bill. So this bill would implement the Attorney General's recommendations. I'm not exactly sure what the it's not like the Attorney General recommended something absolutely concrete. So I think it's really up to you to figure out how to put into place any of the recommendations about, I mean, you've already put into place a prohibition on racial profiling. What this bill, I believe, is supposed to do is collect the data to determine if it's actually happening. So the question is, how do you do that? What are the different ways to collect the data? How do you fill in those gaps? I did put in your file, there was talk about the Connecticut model and the California model. So I put in your files, or Soupy put in your files, copies of the Connecticut law and the California law. And the cover pages of the California law is a couple pages from the Attorney General's office there, because they're responsible for running this, and kind of give some background about how they do it. And they've established an advisory committee to help them go through that. So I don't really have anything concrete for you at this point. I know that there are people who want to speak on this, and you have Representative Hickman. Also, Sheriff Morton had wanted to testify at the public hearing on Tuesday and wasn't able to because of the timing of the hearing. It didn't happen when he thought it was happening or when he was told it was going to happen. So if you have specific questions, I'll be happy to try to answer those.
Senator Bellows.
Thank you. So Peggy, this is a question for you in terms of drafting, and maybe it's a question to follow up with Representative Hickman at a later point. But one of the things that we heard in the hearing was some concern about the implementation from law enforcement, although we also heard some broad consensus that data collection for stops is necessary to addressing root problems of racial profiling. So the question that I have from a drafting perspective is, could we change the statute to say that the Maine State Police or that law enforcement shall collect data with regards to race and ethnicity and transfer that data to the Attorney General's office, and then have unallocated language in terms of that they shall determine the process for data collection under a certain timeline. Because to put the process itself into statute feels challenging, and it seemed like given that there are different ways that different departments are collecting data in the state, it seems like the process might be slightly different for different departments, but not an insurmountable challenge to actually collect the data, should that be our direction. So that's just a process question.
Right. I think that is something you could do. And I don't know if California has an advisory committee. Maybe that's who you call on to put together what data needs to be collected and how it is collected. But you're right, that decision has to be made by somebody. It's probably not a legislative committee that's going to come up with the best way to know how to implement the actual, on the ground collection of the data. So yes, I see that you can say they have to start collecting by a certain date in the future, and then direct somebody, whether it's the Attorney General or a group of people, to come up with the process that they have to implement in order for that data collection to happen. So I think that's what you're saying.
Yep.
Yeah. And Senator Bellows, I was thinking along the same lines, and just in general, that I think we need to keep it simple and again, get at what we're trying to get at, which is to start collecting this information, and especially at stops, but to not perhaps be the group that tells law enforcement how to do that. Or maybe they all do it a little differently, but at least if it's all getting sent to a central location, the Attorney General's office, at least, I mean, if some police departments want to do it with a notebook kept by the chief, or others want to use computers, or others want, I don't know that I want to get into the weeds of that. I just want them to start collecting this information. But I would like to hear from Representative Hickman before we take this discussion further, and his thoughts on, again, just keeping it simple, directing that law enforcement has to start collecting this data, but leaving it kind of up to them to develop the system. Representative Hickman, what are your thoughts? Representative Hickman, are you here? Oh, there he is.
Yeah, I'm here. I'm walking. I'm multitasking in the building. Can you hear me now?
Yes, we can.
Yes, we can.
We seem to have lost you. If you could try again.
Or am I breaking up?
Oh, now we can see. Oh, no, we lost you.
Oh, yeah. Can you hear me?
Yes, we can hear you now. Thank you.
I like what I heard from Senator Bellows and you, Madam Chair, around it doesn't matter the mechanism whereby law enforcement agencies collect the data. Once it's reported to the Attorney General's office, that's where all the analysis takes place. So I just like to keep it simple and let the AG's office with an advisory group or whatever process, you know, determine the best way to look at the data that is submitted to it by the law enforcement agency.
Further discussion from committee, or I guess we should hear from Sheriff Morton, because I understand he wasn't able to be at the public hearing. Sheriff Morton, did you want to weigh in?
Good morning, and thank you for letting us weigh in. I appreciate that. We certainly appreciate the representatives' thoughts by bringing this forward. We had some of the same concerns that DPS had already submitted with you folks, is maybe what the processes would look like on how to collect. Also, I will say I'm a little concerned that some of what we're trying to prevent may occur when we're asking questions of individuals in a vehicle as a regard to race or others, or what exact data we're collecting here. Some of the challenge, to be honest with you, senators, we've never seen this language. All we saw was a title and obviously some miscommunication on the public hearing. So transparency is always important, and we want to be part of the solution. So we're hoping to gain knowledge, and that's our desire to be here today, is at least gain some knowledge as this moves along.
Thank you, Sheriff Morton. Further discussion from committee members? I know there was one other person that was going to be joining us, George Shaler, but I don't think he was able to stay on. I don't see him on anymore.
I see him.
No, I'm here.
Oh, he is. All right. Oh, there he is. Thank
Yeah.
you. Mr. Shaler, would you like to introduce yourself for those who don't know who you are, and share your thoughts, please?
Oh, yes. Thank you so much, Representative Bailey. And my name's George Shaler. I'm a statistical analyst at the Muskie School at USM. And I've done some work on analyzing race data over the years from the Department of Corrections and other local law enforcement agencies. And I think, you know, there's some important considerations to be made when in terms of collecting these data. I mean, I think going forward, I'd be happy to volunteer my services to any committee that comes out of these proceedings in terms of coming up with methodologies, types of analysis that folks want to do. I have also worked closely with Dr. Jack McDevitt at Northeastern University, who does a lot of this work nationally. He's right now embarking on a large study in the state of Kansas around profiling data in Douglas County, which is the area that includes Lawrence, the University of Kansas, and a couple other municipal law enforcement agencies in that jurisdiction. So I'd be happy to volunteer my services to the AG in terms of helping with an analysis plan, data methodology issues, because I think one of the issues that will be important is that, you know, there will be a training component that will be needed for any law enforcement agencies that embark upon this. There will also be, you know, how these data are conveyed in a useful way to the AG's office so that they're not collecting multiple types of data that'll make their job easier. So I think there's some ways that we can make this a little bit easier, but it requires a planning process.
Thank you, Mr. Shaler. Representative Babbage?
Thank you, Madam Chair. Yeah, I guess we're not going to get into the weeds. I just wanted to comment. I found it interesting that in both Connecticut and California, that I think California was observable race and ethnicity, and Connecticut was perceived race and ethnicity. And Connecticut was more streamlined. I'm sorry, Connecticut was more streamlined, yes. California did have quite a bit of reporting out regarding actions taken. But I did find it interesting that California actually, excuse me, I'm getting mixed up, that Connecticut actually informed the person stopped that they had recourse should they want to file a complaint regarding racial profiling, and that they're instructed to instruct the driver on how they may proceed to do that. So that was the difference I saw between the two as well. I wanted to point that out and just say, are we to leave those decisions to the board that we create if that's what we're going to do? Thanks.
Further discussion? Representative Hickman, did you have any thoughts on just the discussion so far? This is your concept draft, but so what direction would you like us to go?
I would appreciate some statutory provision that requires the collection, and then some unallocated language that would allow for the process, the data that is to be collected, and the format whereby it should be reported to the AG's office to be determined by an advisory group or a task force or whatever you'd like to call it. And then I'll let the committee decide the time frame. I do want to comment on one of the things that I've heard now over the years, but in both iterations of this bill. The original bill, LD 1475, lays out all sorts of data points. It lays out hit rate. It lays out very specifically the kinds of things that one would look at if we are going to successfully eliminate profiling. And perception is the most important part of profiling. Not actual, but what is observed or what is perceived to be observed. And so for any law enforcement officer who would feel uncomfortable asking someone how they identify by race or ethnicity, it's not actually required, even in the original bill, that any questions be asked above and beyond what law enforcement officers already do when they are in an engagement with a pedestrian or a driver in a traffic stop or in any type of pretext investigatory activity. I will also say, on the other hand, and when I was 15, and I would walk in the neighborhoods where my friends who were white, and they're predominantly suburban neighborhoods, I was often asked by law enforcement officers in Milwaukee, Wisconsin, not only my name or not only to present my ID, I was sometimes asked what my parents' names were. I was sometimes asked the name of the parents or the friend that I was going to visit. And I just thought that was normal. And so when you are taught to cooperate with law enforcement, no matter what, you typically do answer their questions in an honest fashion, because you know if you lie to a law enforcement officer, it can really not end very well. You can go to court and it will be on a police record that you have in some ways perjured yourself because you have lied to a law enforcement officer. And so I don't think that this bill should require that questions be asked, but I do think that it should require some observable or perceived race or ethnicity, because that is the only way, I believe, on every stop, not just when a citation is given, because that is the difference. And when a citation is given, I would imagine that there are some forms that would require that you fill out the demographic data of the person to whom you gave the citation. We know some of this race and ethnic data exists, because if it didn't, we wouldn't know that we arrest Black people in York County 12 times more for marijuana possession than we arrest white people in the latest 2018 ACLU report. So that's really all I have to say. I think that we are at a reckoning. People want transparency. They want accountability. And I would imagine that if I were a law enforcement officer and I do not have the stomach to put my life at risk in that way, and I honor all of those who do, I would certainly want to ensure that all of my colleagues in my profession, all of them, every single one of them, would not do anything that would infringe upon anyone's constitutional rights. Thank you.
Thank you, Representative Hickman. So Peggy, a question for you. Do you need us to talk about the makeup of this advisory board? Because it kind of looks like we have a direction with Senator Bellows' amendment, I'll call it. But again, I'm not as clear about the advisory board and if we need to have a discussion about, again, the makeup of that advisory board.
Yeah, I would actually really like a lot of guidance. We can go back to LD 1475 and look at what Representative Hickman had proposed as an act to eliminate profiling in Maine. It has the definitions. It has routine or spontaneous investigatory activities. I have mixed feelings about whether or not you need to actually prohibit profiling, since you already have it in training that they can't do it. And then his bill was very detailed about the collection of the data, but maybe we don't do that in legislation so much as that's when you have the experts come in and say, here's what you need to track, or here's the best way to collect it. The other thing you can do is you could, and I'm not sure this is the best thing to do, but you could say, here's what we think we want to collect. Here's the situations where it should be collected, and put a future effective date on it. And then you charge this advisory group to come up with making kind of the on the ground, how do you implement this? And if they identify problems with anything in particular, you could change that in the future. You could amend it in the future.
Senator Bellows.
You're muted.
You're on mute, Senator Bellows.
So Representative Babbage drew all of our attention to the Connecticut law, and thank you, Peggy, for researching that. And I was going to go in a slightly different direction when I proposed just really simplifying the language. And I was going to look at something potentially like page 4, and on page 4 is the substance of the stops and requirement, and basically say something to the effect of no later than, give a deadline, any law enforcement entity with the authority to conduct a traffic stop shall record, retain, and report to the Office of the Attorney General, A, the number of persons stopped for traffic violations, B, characteristics of race, color, ethnicity, gender, and age of such persons, provided, this is important, I think, to Representative Hickman's point, the identification of such characteristics shall be based on the observation and perception of the police officer responsible for reporting the stop, and the information shall not be required to be provided by the person stopped. And then C, the nature of the alleged traffic violation that resulted in the stop. D, whether a warning or citation was issued, an arrest made, or a search conducted as a result of the stop. And E, any additional information. So basically like really paring it down, and then the other language saying something like the Office of the Attorney General and the Department of Public Safety shall be responsible for developing guidelines and procedures for the collection of data, and the Office of the Attorney shall be responsible to reporting annually to the Judiciary Committee of the Legislature on the composition of information about the stops. So that's a slightly different direct, I mean, that was what I was sort of thinking about. And I don't know, Representative Hickman, if that would accomplish these objectives or whether you prefer a different approach. And I really defer to you as the bill sponsor.
May I respond to that, Madam Chair?
Yes.
Thank you. That sounds great, Senator Bellows. I think that in the bill that was accepted by the legislature and signed into law by the chief executive, there is a section on rules. And in the rules section, it charges the Attorney General with consulting with a certain number of organizations to come up with the best ways to move forward. I believe when the Attorney General reached out by letter to some of those organizations, that the task force could be convened based upon his discretion, given some of the conversations that he has already had with some of the stakeholders who are outlined in current law. So I don't know that the committee needs to be prescriptive about the exact makeup and number of people that would serve on that advisory group. I think that that should be left up to the discretion of the Attorney General's office with guidance, which is already actually in the law, about what kinds of organizations and people. The only thing that might be not there are ensuring that people who have been profiled are a part of the process as well.
Thank you. Senator Carpenter?
Yeah, let me play the devil's advocate for a second, because to get data, accurate or otherwise, on this issue is going to turn almost exclusively on the police officer on the street. Let's assume, for the sake of discussion, excuse me, that in the state of Maine there are this racial profiling, and that there are X number of police officers who are wont to do this sort of activity. Do you think that they're going to give you the data that you're looking for? I mean, if they have to record the ethnic data of the people they stop, they all know what you're looking for. And since we agree it can be difficult to determine ethnicity upon a quick view of somebody, I worry that you might end up getting skewed data if you rely on the people. And again, I'm assuming for the sake of this hypothetical that there are police officers who do this sort of activity on a routine basis. They're not going to give you the data that you're looking for. And then your task force or your working group or whatever it's called is going to be getting data in that is not accurate. Just my, I guess I would ask somebody, Representative Hickman or somebody, to deal with that perhaps.
May I answer that, Madam Chair?
Yes.
Thank you. Thank you, Senator, for playing devil's advocate. I'm not suggesting that you're not correct, but they would also be breaking the law if they weren't going to submit the data that would be required by statute. And at some point in the future, that doesn't necessarily mean they won't be held accountable for breaking the law by not collecting and reporting the data. Data is only as accurate, yes, as it is reported. But if you don't set up a guideline for doing it, then you still can't hold anyone accountable because you haven't made it required. It's not like most people are going to report to a law enforcement officer or to anyone that they might break the law by speeding unless they get caught. So I could imagine that a law enforcement officer who might be guilty of not wanting to report the data so that they don't show that they participate in profiling is only going to last insofar as they don't get caught. But if the culture of law enforcement, because of statute, and I've said this in testimony, is that I do expect law enforcement officers to follow the law, and by and large, law enforcement officers follow the law. So when you require something in the law or you prohibit something in the law, I think that if we trust our law enforcement officers to do the right thing, then they're going to follow the law and they are going to report it. We might want to on the advisory group get some advice from law enforcement officers in other states where profiling, the data is required to be collected. And as Representative Babbage pointed out, that in Connecticut, they even have to instruct someone that they stop their recourse for wanting, if they feel as though they have been unjustly profiled, that there is a complaint process that they can go through. So it would be really interesting to talk to those law enforcement officers about the adjustments that they made in doing their policing work when the Connecticut law went into effect, if that makes any sense.
Thank you, Representative Hickman. Further discussion, Representative Babbage.
Thank you. I just wanted to share some thinking I did on this bill because I was looking for consequences. I wondered if, since we're talking about the behavior of police, if their behavior would be in any way affected because they're collecting the data. In other words, if in fact I am a policeman and I stop a person of color, would I feel to make that stop more legitimate that I might be more likely to give a citation than I would otherwise? I mean, to give you an example, I was traveling home from a hockey game in Orono to, and I was on, what is it? 95 heading south, basically in nowhere. And I got stopped by, I think it was a state trooper. And I asked, what's the, you know, how are you doing? And why did I get stopped? And he said, speeding. And I said, really? I said, gee, I have it on cruise control. He said, what'd you have it on? I said, 74. Well, you know, what is the Secretary's, I don't know if I want to say this on mic, but the Secretary of State has said, I think in public, 9 you're fine, 10 you're mine. But the calibration of my, you know, could have been off or whatever. But the person hearing that I had had it on cruise control and was 1 mile per hour off, what he had stopped me for, ended up giving me a warning. And I'm thinking if my skin color were different, would he have done that? And because he did have me at 75. But I, in going through this process, thought that you know, we have it in a couple of states, and probably the incident of any impact on behavior would be minimal. I'm just sharing that with the group because I don't know if you had any thoughts on it, but thank you.
Thank you. Further discussion, or do we have a motion? And just so you know, even if we get to the point that we have a motion, we won't be able to vote on it until this afternoon because Rachel Representative Talbot Ross has another commitment until 1 o'clock. Senator Bellows.
If it's in order, I would just move the ought to pass as amended with the language that I described and Representative Hickman further elaborated. And if that's clearer than mud, Peggy.
Could you ask her to repeat that?
Senator Carpenter is asking if you could repeat the language because he was out of the room at the time that you went through that.
Sure.
It was the page 4 on the Connecticut law.
Before I do so, I realized I didn't have a date in mind. Representative Hickman, do you have a date in mind in terms of when this should be required? January 1, 2022?
There needs to be time.
Yep.
Together. So I will defer.
Okay. So just for the sake of putting a motion forward, no later than, let's say July 1st, 2022, because that'll be the beginning of the new fiscal year. No later than July 1st, 2022, any municipal police department, the Department of Public Safety, and any other department with authority to conduct a traffic stop shall record, retain, and report to the Office of the Attorney General the following information. A, the number of persons stopped for traffic violations. B, characteristics of race, color, ethnicity, gender, and age of such persons, provided the identification of such characteristics shall be based on the observation and perception of the police officer responsible for reporting the stop, and the information shall not be required to be provided by the person stopped. C, the nature of the alleged traffic violation that resulted in the stop. D, whether a warning or citation was issued, an arrest made, or a search conducted as a result of the stop, and any additional information such that the department with authority to conduct a traffic stop deems appropriate, provided such information shall not include identifying information about any person stopped for the traffic violation. And the Office of the Attorney General and the Department of Public Safety shall be responsible for providing guidelines and procedures to departments on the collection of the data, with input from, I think, modeling under the language of 1475, from input from the public that's described in 1475 already. And
I support what we're trying to do here. I'd like to hear from Sheriff Morton. I think we're putting maybe more of a burden than we realize, not only on the individual police officer on the stop, but also the departments to collect and transmit the data. I just would like to hear from Sheriff Morton.
Sheriff Morton.
Thank you very much, Senator. I appreciate that. Again, thank you for the opportunity to even speak to this. I've learned a lot just simply listening here on the work session. I think it's going to be a process. It's going to take time to figure out how to make sure that we collect that. I think Representative Hickman makes great points to perception versus asking questions. That's really one of the areas that I would be most concerned that we would be asking questions, which sometimes I think would cause that divide. And so I appreciate his clarification there for sure. Again, it will be process, systems, taking time to make sure that we record accurately. I am a little bit of a data person, and so I want to make sure that appropriate data comes in is good data, that we're collecting data appropriately, and that it would be useful to make sure that we accomplish the mission. So I do appreciate it. Still an awful lot to work through here, a lot of language. I appreciate Senator Bellows' way that she's laid that out. I would also hope, and I'll just add this one thing, this may not be popular, but I certainly hope that we're not going to just utilize reports or programs from other states. We're a great state here, and we have some tremendous people here. I hope that we can develop our systems for the people, for the citizens of Maine, and not rely on Connecticut or California to guide the way that the folks and the citizens of the state of Maine should be treated. It's the same as those citizens that I hope that we respect law enforcement in our state and the great work that they do here, and not lump us in with all of those other states. Thank you very much.
Thank you, Sheriff. So I heard you talk a lot about it's going to be a process and it's going to take time, and I think we all appreciate that. Do you think the date that Senator Bellows suggested, July 1 of 2022, is sufficient time to get things going?
I'm probably not the right person to ask for that. I certainly think that that's reasonable should this pass. It will take some time to develop systems. Agencies the size of mine have the ability and may have systems in place that we could get there. But we have to remember we have many state, county, and municipal agencies throughout. Rural law enforcement has challenges sometimes with computer systems and whatnot, but I'm sure that once we really have this defined, if that's the direction that we go, we can make it work. I think that is certainly a fair timeline.
Thank you. Representative Babbage?
Thank you, Madam Chair. Yeah, to Sheriff Morton, I heard his comment about his concern about interrogating a person on an issue that they may not be willing to be responsive about or take offense at. And that's the reason I brought up California and Connecticut, is because they are based on observable and perception. So I think we learn from these states about what they're doing, and I think that's better. One of the things I did want to ask, though, because obviously the sheriff's is concerned about the burden on the officer. It seems to me that Connecticut does put a burden on the officer when they are instructed to notify the person of their rights regarding recourse if they feel they're being profiled. But I think both states, if I'm right, when they collect their data and submit their report, they always have the badge number of the officer. And I think that's in the statute. That badge number, of course, is not part of the collective data that is shared with government. But again, I'm thinking that one reason that the Connecticut lawmakers required officers to go to the degree of notifying them that they have recourse if they feel they've been mistreated, that is to exactly impact the behavior of the officer, so that they don't get into a situation where they would where that would probably be needed. Likewise, identify of the badge number of the person taking the information would provide for supervisors and so forth information on number of people stopped according to ethnicity and all of that. That I don't know if that's what we're trying to accomplish, or we want it to be instructive in that way, or if we just want to leave it to the collective data. But I did want to mention the badge numbers were included in both of those statutes. Thank you.
Thank you, Representative Babbage. Further discussion, or we do have a pending motion. I don't think we've had a second yet. Seconded by Representative Harnett. Did you have something, Senator Cobb? Oh, thank you. If there's no further discussion, Sheriff Morton, did you want to say something?
Sorry about
You muted yourself. You need to unmute. There you go.
I forgot to bring my teenage son with me to help me.
Yeah.
I would ask and respectfully ask, and I think Senator Bellows pointed this out. I may have missed the language. Maine sheriffs would love to have a seat on this board if this moves forward. Thank you.
Thank you. I don't think we're gonna dictate who's on the board or who's not. It's going to be left up to the Attorney General's office and Department of Public Safety, correct, Senator Bellows?
The language in Representative Hickman's law in 1475 says, in consultation with interested parties, including law enforcement agencies and community professional research, civil liberties, and civil rights organizations. So I think that either referencing that language, and this is where I'm not a drafter, or repeating that language is how we were envisioning it, rather than spelling out appointments or whatnot. Is that okay? Okay.
Yeah, that was my intent as well. And the only other interested party that isn't currently listed in the law would be people who have experienced profiling. So I think that many of you, I think the chair has received a docket, for lack of a better word, of a gentleman who is asking for relief. I'm not suggesting that this committee take that up, but it just sets out from the perspective of someone who has alleging profiling, just how detailed and how egregious that person's sort of life was after that experience. And so I wanted to bring that to the committee's attention, because there has been conversations that there are no complaints that anyone has seen. And that one is actually spelled out in a lot of pages. And so I just wanted to make sure at least the chairs of the committee saw that complaint.
So yeah, Peggy, let's just add that piece.
So further discussion? I mean, the plan would be that if we're through discussing this at this time, we would break for lunch, come back at 1 o'clock and take this up again, presumably to have a vote at that time. So I don't see any hands, so we will break for lunch until 1 p.m. Thank you all.
Okay.
Representative Hickman, I just want to remind you that your camera and your microphone are on.
Okay. Nope, thank you.
Good afternoon. Welcome back to the Joint Standing Committee on the Judiciary. We have one matter from the morning left to finish up, and then we're going to start on the afternoon schedule. So without any further ado, I'm looking for a motion for to pass as amended on the racial profiling bill.
Excuse
I'm
me,
sorry?
you do have a motion pending.
Thank you. I've now had 3 people tell me that. I'm sorry. Look, you give me an hour off for lunch and you have to retrain me. Okay? All right. So the motion pending before the committee is ought to pass as amended on the bill that we discussed this morning. And I don't even remember 21, whatever. Representative Bailey.
Thank you, Mr. Chair. I just wanted to inquire of Representative Talbot Ross, who wasn't able to be here, if she needed Peggy to kind of summarize what we're voting on. Yeah, Peggy,
Thank you, Madam
if you
Chair.
would do that, just summarize what the motion is for Representative Talbot Ross, who wasn't able to be here earlier.
Right, so LD 2168 is a concept draft. So the motion was to replace that with language similar to what's in the Connecticut data collection law. It's on page 4 of the Connecticut law it should be in your file. So and that's what needs to be collected, and by all law enforcement, the number of persons stopped for traffic violations, characteristics of race, color, ethnicity, gender, and age of such persons, provided the identification of such characteristics shall be based on the observation and perception of the police officer responsible for reporting the stop, and the information shall not be required to be provided by the person stopped. The nature of the alleged traffic violation that resulted in the stop, whether a warning or citation was issued, an arrest made, or a search conducted as a result of the stop, and any additional information, provided the information shall not include any other identifying information about the person stopped for the violation, such as the person's operator's license number, name, or address. And the idea is that each law enforcement agency collects that information and provides it to the Attorney General. And that would take effect July 1, 2022. And in the meantime, we'll use the language from LD 1475, section 4805, which had directed the Attorney General in consultation with a whole slew of interested parties to figure out the best way to make this happen and to analyze the data. And the change there is to add in those people that the Attorney General needs to consult with, people, at least one person who has been the subject of profiling. So
Before we go any further, Representative Babbage, would you join us in the chamber, please? You're the only missing person right now for a vote. Thank you. Any questions of Peggy or anybody else as to what she was just bringing to committee? You
Mr.
all
Chair?
set?
Yep. No, I only had one quick
Senator
question.
Bellows, would you join us also? I'm sorry. Representative Talbot Ross.
Yes, thank you, Mr. Chair. To Peggy, the section 4 of the interested parties, in consultation with interested parties.
Yes.
Law enforcement professional officers. I'm sorry to ask for this, but I'm seeing a critical stakeholder group that's not included in, I know it's including, so it's not limited to, and that's people with lived experience.
I think that is something that Representative Hickman had said, and I believe I think we're talking about people who have been profiled in stops, right? Is that what you're, no?
Yeah, what I'm not seeing there is, I'm not seeing, and that doesn't mean you didn't discuss it, so my apologies, but yes, the lived experience and also the language in consideration of racial and ethnic populations, that the interested parties are put together in consideration of.
Yeah, of the racial and ethnic diversity of the state.
That's correct. And then folks who've had lived experience.
Okay.
Yeah, so it sounds to me like you did discuss it, but I'm not sure I heard it in the overview.
I don't think I phrased it that way.
But it will be included, is that what I'm understanding?
I don't think we talked about the racial and ethnic diversity being included in the group of the advisory group.
Right,
I would see that as a friendly amendment to my motion if that's in order with the chair.
Is anybody having an objection to adding that language to Senator Bellows' motion?
I would second it as I seconded it.
I would like to hear it if I was in transit. Go ahead and, well, what we're doing is adding, you're familiar with Senator Bellows? Representative Babbage? And so what is being proposed is that the language that we've been using on the other bills with regard to the makeup of, or the interested party group, if you will, be the language with regard to ethnic and racial diversity of the state be added to that when those people are, those parties are chosen.
Mr. Chair? I think we're still in discussion, right, before we take our vote?
Yeah.
So,
one second. Yeah. Did you get that, Representative Babbage? Yes. Okay, Representative Talbot Ross.
thank you, Mr. Chair. My only other friendly amendment to the amendment is that we have had these kinds of work groups put together before to look at racial profiling in the state. In fact, several members of the Judiciary Committee, my colleagues and I, were fortunate to participate in a task force on racial profiling that was created in statute. It lived for about 3 years, and it is why we now have standard operating procedures around racial profiling and a racial profiling mandate by all law enforcement agencies in the state, as well as training on racial profiling at the Maine Criminal Justice Academy. My point is that in participating on that task force, there were racial and ethnic the racial and ethnic population was represented, but it was represented at a considerable minority of the number of people participating. So my point in raising this is that even with the language around including in consideration of racial and ethnic populations for the interested parties, I'm still concerned that with so much law enforcement and others noted, that you could end up with a committee that is still predominantly white. And I say that because it's very, very important that we don't create just bureaucracy for the sake of creating it. And I'm concerned that for this bill, we might need stronger language to ensure that there is adequate representation by the racial and ethnic populations. I hope I'm making myself clear. I would like for it to say, I'd like for some language to acknowledge that it is important for racial and ethnic populations to be well represented on in this interested parties group.
I'm not quite sure how to do that. Looking for suggestions.
So I think one of the considerations here is that this is not necessarily a group that's being established by the statute. It's who the Attorney General, we're directing the Attorney General to come up with these, the standards, the practices, how to implement the collection of data and report it and analyze it. And there's not really a committee established, but we're directing the Attorney General to consult with a lot of different people. So I think we can we can probably word it that the people he consults with, he needs to make sure that he consults with racial and ethnic populations. Yeah, I have to work on the wording there.
Thank you. I do understand the difference, Mr. Chair, and I appreciate trying to think about it. I just got nervous thinking about even the disproportionate ways in which we would consult people, interested parties. In this particular area of work, I think we have to be a tad bit more explicit. So I thank you for the explanation, Peggy, and for the opportunity to have this considered.
Are we all set?
Mr. Chairman, I was wondering if you,
Go ahead.
so do we want to urge, it is important that representation, that adequate representation come from disproportionately affected populations?
Just from a drafting standpoint, I think we could say something like the Attorney General shall ensure that those consulted include. I have to figure out exactly how to put that together, but put the onus on the Attorney General to make sure that the people he's consulting with include a good representation of minorities or racial and ethnic population in the state. Is that what you're looking for, Representative Talbot Ross?
Yes, that's exactly what I was looking for. Thank you very much, Peggy. And thank you, Mr. Chair.
So is everybody comfortable with that being a part of Senator Bellows' motion? Right, we're going to look at it again for any further discussion of the amendment? If not, motion ought to pass as amended. Oh, I'm sorry too. I'm waiting on Senator Bellows to come down. I thought she was, okay. And I'm trying to get back on again. I've been bounced yet again. I think it's Peggy that's doing it to me.
It's me. Now that all of my technical problems are fixed. Thank you.
Good, you gave them to me.
Yes, sorry about that.
All right, I believe we have 7 members in the chamber. Would the committee clerk please call the roll?
Representative Cardone. Representative Cardone is absent. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Curtis. Representative Curtis is absent. Representative Reckett. Representative Reckett is absent. Senator Bellows.
Yes.
Senator Bellows votes yes. Senator Carpenter.
Yes.
Senator Carpenter votes yes. Representative Bailey.
Yes.
Representative Bailey votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Talbot Ross.
Yes.
Representative Talbot Ross votes yes. Representative DeVoe. Representative DeVoe is absent. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. 7 members voting yes.
Thank you. 7 members voting in the affirmative, no members in the negative. The ought to pass as amended. Hold on here. Motion passes. I'd remind my committee members who are not here in the building that they will have 24 hours to contact their leadership, Speaker's office, of the Senate President, to if they wish to be recorded. All right, now, is that all we're going to do there, Peggy?
Yeah. I don't think so. I think you have a few more things on your agenda, and although I think you're moving to your 1 o'clock agenda.
Yes. Yep.
But don't go away after that because we still have the Ayers bill.
Right. All right, we're going to go now and turn to our 1 o'clock agenda, which includes 3 bills, 1392, 2094, and 2118. And I guess I'm a little unclear as to where we are. When we last left the tribal matters, we had it'd been indicated to us that, oh, wait a minute, I'm sorry. I've got to wait for my committee members to get themselves remote again. Representative Newell, thank you for the use of your desk. I think I've got her desk, don't I? Yeah. That's fitting somehow, taking up the tribal stuff. Give us just a moment until the members get back in their places. Representative Babbage is back. Senator Bellows is still missing. I don't see Rachel. There we go. Senator Bellows is back. Representative Talbot Ross. Hopefully she's logging in. While we're waiting, I'll welcome Chief Francis of the Penobscots, Chief Sabatis of the Maliseets, Vice Chief Dana and Vice Chief Newell from the Passamaquoddies, Ambassador Dana from the Penobscots, and Representative Rena Newell from the Passamaquoddy. Welcome. I don't really want to start without. Yeah, would you please? Representative Bailey is going to scoot down the hall and see if Representative. What's that? I'm missing it. Is Representative Talbot Ross on there? Yes. Okay, all right. So who wants to tell us where things stand? Maybe I would turn to Chief Francis, with whom I had a conversation just as we broke for lunch. What can you tell us, Chief, where things stand?
Well, we just think you should do a unanimous ought to pass here and move forward. But I appreciate it, Senator and members of the committee, the opportunity to talk. I would have to say at this point, I don't quite know where we're at. I think the tribal leaders are extremely frustrated at this point. We had the opportunity to talk this morning, and on Monday we thought we were making some progress and at least had some. We're in a decent place in terms of criminal jurisdiction and some tax issues. We're focused on seeing if we could make some progress in the geographical areas in which some of the tribes could acquire trust lands and what that process would be, some fish and game issues. But after talking to our representatives and lawyers in those conversations, it now sounds like, fish and game and land acquisition is off the table. And it sounds like progress can only be made on tax issues if it's done in a manner that doesn't change the implementing act and puts the tribes at the whims of every leadership in state legislature in the future in terms of placing us under state law. And with respect to criminal jurisdiction, it's our understanding that that jurisdiction is only supported if it's on tribal reservations. So it seems that we've lost some progress. You know, LD 2094 has been pending in front of this committee since February, had been worked for 7 months before that through an open work group process, which was recorded and open to the public and anyone that would be there. You know, this work began 16 months ago with the mission of modernizing the Maine Indian Land Claim Settlement. And if we do that a few issues at a time, then let's have that discussion. But the changes have been done to the Implementing Act in a manner, or have to be done, that respect the tribes as governments. And I read the governor's letter last night and appreciate that the letter indicates that the governor's office is willing to continue discussions, but I'm confused as to what the discussions will entail. Is it the governor not willing to amend the Implementing Act? Is that the starting point? Because it appears to be the case at this point. And if so, for what issues and when will that discussion take place? I asked our representation if any meetings were scheduled over the last week, and there simply are not. And so I'm not clear on how that dialogue is going to happen. The only way I have seen the dialogue take place is when this committee really has conducted some sort of oversight on them. So I think the committee staying engaged is going to be extremely important. You know, we often heard from August of last year through January that this was a legislative matter and that the administration wasn't going to get involved in that at that time. And now there seems to be a different approach to try to take it out of the legislature. So much work. And as a government leader, I understand the times we're in with the coronavirus hitting in March and all that's gone into that for leaders of states and tribes and local governments. And I certainly appreciate the governor's pressures there and think the state of Maine, quite frankly, has done a tremendous job in addressing that issue and attempting to keep Maine people safe. And I certainly on a micro level have been doing the same with our own people, as have all the chiefs. And so I understand how time consuming that has been. But again, you know, it was 9 months of a lot of process before we got there. We've continued to stay engaged to the extent we could during that period of time. And a lot of work and resources have been devoted to this LD, and I don't want to see that go to waste. I think the committee owes it, quite frankly, to the state and the tribes to move this bill forward. If there are concrete issues that members want taken out, then let's discuss what those are. But otherwise, we would like the committee to keep next week's work session and vote on LD 2094. We are still willing to work with whoever it takes to try to move this thing forward. We just feel like at this point, extremely discouraged that we're at a place that doesn't follow the legislative resolve in terms of the work product that we think we can get out of this, that acknowledges tribal sovereignty, that acknowledges the inherent rights and privileges of tribes and gets us to a place where we can truly be successful and modernize this relationship. So whether we can do that over the next 6 days or not seems daunting, but I will just tell you, we're committed to the process. We're committed to doing that. But I will just say in the end, with all this frustration, the tribes are really at a place right now where, and that's today, I don't know where we'll be next Friday, but that we believe LD 2094 just needs to move in its current form, and that we need to have a legislative process at the very least for all our work, for an up or down vote on this thing, and allow people to participate in the process, including the administration, and see where it lies. But we just feel like we're at least due that. And at this time, I wished I could report better news as to where we were, because we were committed to doing that. We understand compromise and all of those things, but we can't compromise further who we are as a people, who we are as governments, and continue to submit to state regulation around sovereign governmental activities. And so that's just kind of where we are. And I hoped, again, that I would have better news. But I think that we're at a critical time with this bill right now. And, you know, I talked to the other tribal chiefs, and, you know, we often see this, whether it was the tribal state work group, whether it was other efforts I've been involved with over the last 15 years, some folks over the last 25 years, developing the At Loggerheads report, for example, and a whole lot of other things from the late 90s to today, that continues to bear a process that is all too familiar. And that is, if we're in the first session, let's get it to the second session. We're going to carry this over. We're going to push it to the next legislature. We're going to do this. We're going to do that. And you know, and I'll speak for myself. I'm the ultimate optimist. I continue to grab the olive branch, and we have to remember the tribes were invited to this. The tribes didn't come and ask for this process. We were invited to this with a clear mission and goals that were set from that invite. And despite all our skepticism, we grabbed onto it because we think it's in the best interest of our communities and people and entire state, quite frankly, to do that. And so it's a bit of a gut punch to continue to hear that there's heartburn around any recognition of tribal sovereignty. And we understand there are issues like gaming, like other issues that we need to talk about that affect entire communities, our neighbors, etc. But it just can't be a carte blanche no all the time. So we're concerned with where things are. We're continuing to keep working towards a deadline next week. I'm sure we'll have more information for you then. But Senator, that's kind of where we are now. And I want to end by just saying I've appreciated this committee. And I will just say that anything that moves into next year and costs us another year, and this is not a threat by any means, it's just a reality that the resources of the tribes are extremely tapped on this issue at this point. I don't know how long Penobscot can sustain the number of representatives we have on this issue, and the amount of human resource we continue to put into this. So I will just say that we've acted in good faith. I think we're trying to make the compromises that make sense, but at the end of the day, there's either going to be an acknowledgement of kind of a separate autonomous situation in Maine, or there isn't, and that's kind of where this legislation leads. And so I'll just close by saying I've appreciated this committee. I've appreciated the legislature's engagement. And I also want to say to the Attorney General's office, I know the amount of time they've put into this, some bright people over there trying to find solutions, and I've appreciated their time as well. It seems that we're just at a place where we haven't made much progress in dealing with the next level of this process. So thank you for allowing me to speak today on that.
Thank you, Chief. Are there other chiefs who would like to weigh in, or your attorneys? Linda Pisner was on. I'm not sure if she's still there or not, but she is. Okay. Ms. Pisner, do you want to add to that?
Senator Carpenter, this is Linda. I am here. I had forgotten to undo my mute. I would defer to other chiefs, tribal representatives, or tribal attorneys to get all their views out on the record for the committee before we respond, if that suits the committee.
All right. Chief Sabatis?
Yes, I echo Chief Francis' sentiments exactly. I mean, this is something that we've had conversations about. And again, I'd like to also express my gratitude for all of the work that's taken place, but we're on the same page.
Are you still there?
Senator, this is Chief Francis, and I just want to clarify that if I said that no meetings took place last week, that was misstated. I meant there's nothing scheduled for next week going forward. And so I just wanted to clarify that.
I keep getting kicked off, so I'm only getting part of this. Chief Newell or Vice Chief Dana, either of you like to comment or no? Ms. Binney or Mr. Hinton or Corey? Any thoughts you want to add to that? So, see if I understand where we are with regard to the discrete items that we had talked about around criminal jurisdiction and taxation. We don't have agreement. We don't have language. Sorry, Mr. Taub, I should have asked you to weigh in as well. Do you think we're looking to schedule a day next week to vote on those and I guess to make a decision about 2094 overall? Do you think it's worthwhile for you folks to try to bring us something by next week, Thursday or Friday? Anybody? Would you wait just a minute, Representative Cardone? I see your hand. I'd really like to hear from the tribal attorneys or the Attorney General's office first. I've never known that many lawyers to be that quiet.
Senator, if you'd like,
when being invited to speak. Go ahead, Ms. Binney, go ahead.
Well, I'll defer to Mr. Taub if he wants to go first, but I saw that we were both trying to talk at the same time.
Why don't you go ahead, Allison?
You're on. Go ahead. Mr. Taub, go ahead. Whoever.
So, I mean, in my view, I do think that, I thought we were going to make more progress on taxation and criminal jurisdiction provisions this week. I mean, I think that we have a better understanding where the governor is. I'm just not sure that now that that's been clarified, that the tribal leaders can get to a compromise on those. I think that they are willing to make some changes to LD 2094 to at least address some of the issues that we've heard from the Attorney General's office. But I'm not sure if we can get to a place that will make the governor feel comfortable enough with it. But I also think that at least from my schedule for next week, that I've definitely left my schedule open to continue to have dialogue and try to thread the needles here. So I think also on land acquisitions, I just raise it because that's a really important issue for Penobscot. And so one of the things that I think the tribal leaders have to figure out is if there is more dialogue taking place next week, and we're willing to do it. If it's only those two issues that can be addressed, and if taxation and criminal jurisdiction can't be addressed in a manner that the tribes are comfortable with, then I think we're at least where Chief Francis says the tribes are, is they want to move LD 2094 as a comprehensive bill and at least have the votes so they can figure out where the rest of the legislature is.
Mr. Taub, you want to join us? And then Representative Cardone, I'll come to you after that.
Thanks, Senator. Yeah, I mean, I guess just to offer you sort of my perspective, which is that I think all of us, the tribal attorneys, the governor's office, the AG's office, we've been working extraordinarily hard over the past few weeks, and we've had a lot of meetings. I mean, I'm losing track of like how many meetings we've had at this point. But I think we've been meeting almost every day, and some of those meetings have gone on for 2 hours or longer. And I feel like we've developed, and we've really had this relationship all along, that I feel that we've developed a very good relationship with the tribal attorneys, and we've had a lot of candid and open discussions, and we've really, I think, made a tremendous amount of progress. I don't think we've reached any impasses yet. I mean, there are certainly some issues that are going to be difficult. And just to sort of follow up on Chief Francis, and just to give the committee an idea of an example, We've had discussions about whether changes to the tax provisions should be part of the Settlement Act or part of Title 36 where the tax code is. And that's not something that I don't think either side has yet taken a firm position on. I mean, I think certainly from the state's perspective, we've expressed sort of our concerns about where the proper placement for that is. From the tribe's side, they've done the same. I don't think we've reached any kind of impasse on that issue. I think that and sort of the other issues that we've talked about, there've sort of been some similar issues that have come up in terms of the criminal jurisdiction, in terms of the specific types of crimes that the tribes would have jurisdiction over and the geographic scope. We've had sort of a lot of discussions that have focused on what those issues are, and a lot of discussions about why each side sort of has a view about those issues. But again, I don't think an impasse has been reached on those either. Having said all that, and I'm just trying to be as practical and realistic as possible here. I mean, between now and next Friday, in the sense of the kind of work that's still needed to get done, we are certainly, the AG's office is certainly committed to continuing to work as much as we possibly can between now and next Friday. But I guess I would just say that these issues, I mean, there is still work to be done on these issues. And then even when we sort of reach an agreement in concept on the issues, then we still have to reduce those things to a piece of legislation. And I think, it's not impossible that we could come back on Friday with some legislation, but I guess I just want to say that from a realistic standpoint, this stuff takes time, and we will work as hard as we can, but I just don't want to sort of lead the committee down a path of thinking that by next Friday we're going to have some legislation for them, because I honestly just don't know whether or not that will be the case or not.
Thank you. Representative Cardone?
Thank you. From what I've heard, it seems to me that the tribes are unanimous in that they would like to move this bill forward in its entirety as it is, or with minor changes, maybe some significant changes to certain parts, but they want to move it forward as a whole. I think they have a right to have that done. And I think B, based on everything that I've heard, including Mr. Tall's comments, which were made in good faith, that if you wait another week and put more time and more effort into this, we're going to be at virtually the same place we are right now. I am not present, obviously, so I can't make a motion, but I would offer that I think the solution here is to have one of the members of the committee move LD 2094 now, whether as is printed or if there are certain amendments that the tribes want to offer, we can talk about those. But I think it ought to be moved today and voted today, and then let the chips fall as they may. That's what I'm hearing. That's my suggestion.
Thank you. Other comments? Senator Bellows?
So I would be perfectly comfortable, and just to refresh the committee's memory, Sam Sempt drafted on my behalf an amendment based on the public hearings and the work sessions that is LD 2094, but amended to reflect some of the input and feedback that we heard. And I'd be ready to do that today. Although I, like Chief Francis, am an eternal optimist and always hoping that maybe people will come together and find a way to yes. But I have a few questions based on, oh, I'm hearing an echo. Okay. I have a few questions based on the letter and what I'm just not clear. Ms. Pisner didn't elaborate in terms of where the governor or the governor's office stands with regards to LD 2094. The letter indicates a desire to have more dialogue, and we know that there hasn't really been that dialogue around LD 2094. And the goal of 2094 including my amendment, is to modernize the Maine Implementing Act so that the tribal nations in Maine can be restored some of their sovereign rights that every other tribe in the country is able to exercise. So I guess my question for Ms. Pissner is, can you let us know, is the governor amenable to modernizing the Settlement Act itself and that question of sovereignty?
Ms. Pissner, are you in a place where you think you can answer that?
Yes, if I could address that question in the context of my response, and I will not belabor this to all of what's been said so far. So there's a couple of points. One, is there value in continuing to work towards something for next Friday? Yes, I think absolutely there is. And I believe on Wednesday you heard from parties around the group that we thought that there was some traction, that we had solidified as a discussion group, and we're making some progress. Having said that, I don't see why we would drop that opportunity to come to some agreement, whether it's a full 23 recommendations or on 2 that we think that we could actually wrestle to paper. Secondly, as far as the legislative process, and I totally agree with Chief Francis, who described this as a legislative process. This has been a legislative process. The administration was not invited in to frame it, to participate in any voting fashion on the task force. There was very little opportunity for comment. There was comment during the task force proceedings on certain issues. There were no stakeholders heard. I should not exaggerate that. There may have been stakeholders heard, but I'm not aware who they were. It was generally not a stakeholder process, which we would normally go through if we were looking at a change to a law of this magnitude. Landowners, other kinds of groups who have interests involved. I'm not saying that we line up here or there. There are municipalities who have views about this. The governor's office hears from all of these people. So by the time it came to the report is out and we were being asked, where are we with this? And the legislative process comes to a conclusion, and then the governor decides what she's going to do going forward. We are doing our best, given the circumstances we find ourselves in, to move forward here. There is no way that we could answer a broad and general question like the one you asked, Senator Bellows, with all due respect, whether, because it's simply the kind of question that we would all of us have our own perception about exactly what it means. And too often I see people think that they have agreement when they don't have agreement. So I really feel that there's an opportunity to move forward specifically in the next week that may or may not come to pass, to continue to work during the interim and come back with some sort of a report for the 330th Judiciary Committee about what we have discussed and what we think can be resolved. All of these concepts, with few exceptions, are ones that are complex. You may recall the VAWA bill that we worked so hard on together. There was never any question but that the governor supported that right out of the box. It took probably well over 100 hours of meetings for all the different interests to talk about how to work out the language of that bill. That's not something that we caused or you caused or anybody caused. That was just reality. And that's sometimes what happens when you have state and federal law and a lot of complexity. We want it to work, whatever it does. We want it to be understandable because, believe me, the state is tired of being sued. We don't want more litigation. So I think there are a lot of positives to be gained here. The choice, of course, on what you do with a bill that's pending in your committee today or next week, totally up to you.
Follow up, Mr. Chair?
Sure, go ahead.
So thank you for your willingness to continue to engage in the conversation. I think what I heard you say was that there might be 2 areas of agreement out of 23. And I guess for me, and I said this on Wednesday, that one of the key pieces of this bill is the section 1 and 2 in terms of providing that means tribes enjoy the same rights, privileges, powers, duties, and immunities as other federally recognized tribes. Is that even on the table for discussion next week? If it's not, what are the two pieces that are in fact on the table for discussion? Because I think as committee members, we need to make a decision about whether what's on the table is enough or not. But so my first question is that on the table for a conversation, or is it off the table for now? And what two pieces are on the table?
Let me jump in. I think the only two things that are on the table for language, trying to get to language, was criminal jurisdiction and some issues around tax. I don't think what you're talking about had been broached yet. I could be wrong.
I'd like to hear from the governor's office, because I know I mentioned it on Wednesday, and I know that all of 2094 is, for our purposes, on the table. But for Ms. Pisner, is Senator Carpenter correct? Is it just criminal jurisdiction and taxation at this point?
I think that it's correct to say that we talked about, and the AG and the tribal attorneys have had far more discussions than we have had with the tribal attorneys. And now we're all three sets of lawyers and some key policy people where necessary participating in these discussions. We've been a little busy the last 5 months. I can't begin to tell you what it has been like here when everyone left Augusta and we were still coming to work at a point when there was no way to know exactly what the consequences of that might be to us personally. It was around the clock, literally kind of work under very stressful circumstances. There really wasn't time for anything else. I've never experienced anything like it. I still am getting chills just talking about it. I'm hoping we're on our way out of this. But so that is in part an explanation of why we aren't farther than, where we might like to be. And so what we were doing was trying to focus on things where we thought we could get an agreement. What you always do with negotiations outside of the legislative arena, I might say, I'm no expert on that. But if you're negotiating matters, you usually start with the things you can get easy agreement on. And then you try to work from that, because part of the process is building trust, building understanding of each other, and what considerations there are that are being brought to bear by the different parties. A lot of that information is not something that would necessarily come up during a legislative proceeding. So that's why we started the way we did. We did also have some discussion about land acquisition. I'm not aware that that's off the table. As Deputy Attorney General Taub said, I don't know that we have any impasses. There have been some positions tabled that would be preferences by both sides, I think, but I'm not, if there is something that's not on the table, period, I'm not sure what it is. To answer then, with that sort of intro, your particular question, Senator, is that from the perspective of getting a law that requires this many changes, state level, federal level, in place, requires looking at all the different implications it has. In essence, that's what your committee did by reading the nutshell on federal Indian law to get a sense of that. Even that, of course, is not entirely conclusive, but it was a heavy lift, and I'm really amazed, and I acknowledge all the hard work that you all did to get through that so that you would have an understanding for context. For, I think, the state and for lawyers generally, you work up to that big question of sovereignty, because the question of sovereignty for the tribes is represented in those recommendations. So if you take the overall question, nobody is entirely clear what the answer to that is. If we say we might be able to support that. So that's why we're working at the particulars. and we'll come to the big question. I think that there are clearly, and I've come to have a great deal of respect for the emotional considerations that the various tribes have toward the concept of sovereignty. I get that to the extent that I'm capable of getting that, being the person that I am, not a tribal member. But I think in order to come to an agreement that's actually going to stick, that people can vote for, get enacted in the full legislature and signed by the governor, we need to do the detail work now. I'm sorry it couldn't be done ahead of this point, but this is where we are.
Oh, okay. All right, let me get back. I've been in and out of this thing so many times. That's okay. That's okay. All right. Evangelos, Harnett, and Babbage. Representative Evangelos.
Thank you, Mr. Chair. I have several areas I'd like to speak about, just speaking for myself, not the committee. And Ms. Pisner, we all appreciate the circumstances which the government's been operating under, and that you have been up here somewhat alone without us. But I do want to point out that the vast majority of members of the House and Senate have voted and indicated that we want to get back up here and join you with this work. And, you know, it's difficult for me, and Senator Carpenter asked me not to ask you this question, so I won't. But it's difficult for me to believe that we can have a level playing field of negotiations when the one issue remains resolved. It's a simple yes or no question, you know, and I'm not asking you, I'm making a statement. We need to get back to work and go back into session so that the exercise of the balance of powers between the executive and legislative branch can resume. And, you know, the governor has to let us know when we can come back to work, because one party is not going along with it. They're obstructing it. So it's difficult for me to believe how we can negotiate these matters when we know that all of the efforts that went into the task force, the near unanimous recommendations of every item in the task force recommendations, can just die if we continue to govern by executive emergency rule and the legislature doesn't get a chance to come back and weigh in. So we need an answer to that question, and so do the tribes. You know, I want to speak to the nations, the tribal nations, for a second. Again, speaking for myself, but I was in Washington County in the 1970s, and this is starting to feel like 1980 all over again. We've got the imposition of deadlines, which happened in 1980. We get negotiations that are forced into a corner because we're running out of time. And, you know, Mr. Woodcock, Timothy Woodcock, admitted that that was the case in 1980. And we have an issue of separation of power. A bill came forward and a recommendation came forward that the House and Senate would put a task force together. Our chairs did a remarkable job. The Attorney General's office, Mr. Taub, has been fantastic. And the contributions of our native nations it's been unbelievable. And, you know, the only thing, what are we asking for, the advocates of LD 2094? What are we asking for? We're asking for what the other 49 states already have. This shouldn't be that difficult. And I just am not going to vote in support for anything that continues Maine status as an outlier in this arrangement. Just in the last 2 or 3 weeks, we've seen major decisions in Oklahoma and in Big Sur, where the country's coming around to realize that sovereignty is not something that anybody can grant. It's an inviolable concept. The United Nations Declaration of Human Rights stated this. So I'm feeling uncomfortable that I even am voting on conferring something that you already have inherently. But we have worked in good faith, and I want to continue to do that. But we need to get back into session so we can continue the discussions in a more balanced manner. Thank you.
Representative Harnett.
Thank you, Mr. Chair. And thank you, Ms. Pissner. And as Representative Evangelos said, I can't imagine what the last 5 months have been like for the executive branch, continuing to work when we are not here with a great deal of uncertainty about one's health. And you know, I keep hearing today that, you know, the legislative process has to come to a conclusion. And I think that was one of the major points Representative Evangelos was driving towards. If we don't know it's going to come to a conclusion, I'm not exactly sure what we are doing. We can hope that a lot of work is accomplished over the next week, but I still don't know what happens after that. If we vote something, are we ever going to be able to present it to the full body? Or is it just going to be, well, we'll deal with this the next session? And I also understand that when one negotiates, you often look for the low-hanging fruit upon which you can find agreement and deal with the difficult stuff later. And I don't want to speak for the tribes. I certainly don't want to speak for the tribes or any other member of this committee, but this has always been about sovereignty. It has always been about the inherent sovereignty of Maine's First Peoples, of the tribes that are here with us today. And if we can't have a discussion about that because we need to figure out some things on taxation, which may be by amending Title 36 as opposed to actually looking at the Settlement Act, I think we're missing the point. This is about recognizing the sovereignty that the tribes have and that tribes have all across our nation. And I am just terribly uncomfortable with saying, I guess it's going to go to the next legislative session. We're celebrating our bicentennial, the state of Maine. Obviously, there were people here long before us. We've had 200 years to try to get this right. I don't think we can keep asking the tribes as co-equals to come and negotiate against themselves and just moving it. Well, we have more to talk about, we have more to do, there's a lot of detail. Either we recognize the sovereignty or we admit that we're never going to do so. And I certainly hope that's not the case.
Thank you. Representative Babbage.
Thank you very much, Mr. Chairman. I want to thank everybody that's on this meeting. I think it was, I believe it was Valentine's Day back in February that this bill was introduced to the Judiciary Committee. And I was in the unique and unusual position of chairing at that particular time. I don't know why, but I realized the history that we were about to embark upon. I want to confess that the last 5 months for me have been, there's been no issue at which I have dived deeper than in this one. I actually was a little disappointed in the unanimity of the task force because I thrive on education from dissenting points of view and filtering that out and trying to get at the bottom of it. And when and I know you know, I found the representation of the tribes there by the tribal members and their council to be outstanding and forthright and genuine. And whether it was or not, I mean, you know, I respect terrifically the people involved here. The task force had the Attorney General represented, and I think our AG is progressive, and he made a decision to be an ally of the process in order to make recommendations happen. And what I mean by that is, as a legal expert in Maine law, they responded to what the legislature proposed and pursued how and if it could happen. And that's an important process. What they did not do was to take the status quo and become the counsel for the status quo, and see and then explore whether or not, from a devil's advocate point of view, that it could fly. Not, at least not to the satisfaction where I like stakeholders to express points of view that I can't characterize the task force. I know you delve deep and all of that, but when it came to us, it put on my shoulders a tremendous responsibility to have to educate myself. And all of you have been very helpful in that, and I appreciate it very much. I will say, if we have an up and down vote on the mere language that was proposed in February, I think it's an indictment of the last 5 months of our work. It may come to that, but it seems to me that we have done a tremendous amount of work where we can agree on what we can agree on, and if there are areas of disagreement, then we should acknowledge that. But I respect everybody in the process. I desperately want to get the tribes not only the dignity they deserve, but an opportunity for prosperity that's going to give their children a real chance at a prosperous future. Now, given all of that, we have a special situation here in Maine, given the timing of federal law that makes certain consequences real to doing that. And we do have to explore that. So I will tell you, I'm hoping that we'll have language other than the mere bill I certainly can vote on that as well. And but my point is, I look for as much agreement as we can in order to accomplish what we can. And so I am glad we have an extra week in order to do that. So thank you.
Thank you. Thank you, Representative Babbage. Representative Talbot Ross.
Thank you, Mr. Chair, and thank you all for being here today. I want to simply add my voice and appreciation to the Attorney General's office, to the Governor's office, to the tribal chiefs and the tribal attorneys, all tribal members who've been participating in this process. However, I did want to just mention, since Linda Pisner mentioned the hardship of working the last 5 months, of which, again, I would personally have an appreciation for, given the pressure that this pandemic has placed on all of our lives. I would only ask that it also be acknowledged that these issues of sovereignty, and I would dare say systemic racism, is one in which the tribal community and the racial indigenous populations deal with acutely every single day in this state. That while I understand people have only had to contemplate the impacts of COVID-19 in their lives, the tribal populations and racial populations of this state every single day are under an acute form of oppression and injustice in which what has come before the legislature should be taken with immediacy and urgency. More talk and more stalling, if you will, and I don't say that disrespectfully, I just know how it feels, is discouraging. It's painful. And I say to the tribal communities that I'm sorry that we have arrived here. I want to ask Chief Francis and Chief Sabatis to be very clear. If an additional week is necessary for these talks to continue, and what you need from us in order for next Friday to be most successful. Because this is an absolute travesty for the state of Maine to continue to debate the issues of sovereignty. And I would like to hear from the tribal chiefs once again, what it is that is needed for us to move this forward. LD 2094, what do you want? Thank you.
Either of the chiefs would like to respond. Representative Reckitt, I'll come to you next.
Well, I can take a crack. Thank you, Representative Talbot Ross, and for your hard work on this bill as well. I would say two things. One, to Representative Babbage's point, you had no greater devil in the room than Mr. Taub at the AG's office, who challenged about every point of law that was raised in there with the what ifs and again, extremely bright people over there that were articulating some of the potential pitfalls, and so I don't think he's the devil. I'm saying that he's certainly the advocate in the room for those kind of what if debates. So, and secondly, I would just add that to Rachel's question is, we think, sure, we're at a tough place right now, and I think the optimism of the tribes is fading daily, and with so much optimism, not just us. The thing that often gets lost is our own politics we have to deal with back home, and what is really going on with the condition on the ground for real people. And I thought the representative really articulated that. There's been for the last 4 decades, there's been multiple bills, half a dozen gaming bills, half a dozen jurisdictional enhancement bills. All of those things that have taken place for the last 40 years are just constant gut punches, quite frankly. And it's in the morale and how that affects people. And to see the optimism on people's faces at the beginning of this process by the way it was initiated seemed different. And so I would just say in this, to that question, I don't think it hurts to have this work session next Wednesday or when the committee schedules it, to allow the tribes to continue to talk. We have very smart people on our teams. I mean, we know a bill in its entirety voted out today, and we know what the votes are on that. We know what our odds are on this issue, and we know the politics behind it. And quite frankly, speaking for myself, I don't like our chances on this. But my point is that with my earlier comments is we at least deserve to understand where people are at with this bill. So I would advocate that we do have that session, give people the opportunity to weigh in. I don't know where my optimism level is in terms of if we're going to get to a place that fully acknowledges the things that many of you have spoke about today, that is at the very foundation of the direction of this bill. But I don't think it hurts to continue to allow people to brainstorm around this issue for the next week. And what we would need from the committee at that point, I think, is a commitment to support this effort and to put the full weight of the legislature into demanding a better tomorrow when it comes to the relationship between the state of Maine and the tribal nations of this state. And as was mentioned, we fall far behind most states in this country when it comes to economic achievement, educational outcomes, health disparities, our ability to regulate and provide enhanced services to our people. The tribes of Maine have been stuck decades behind other tribes in this country because of it. That's the goal and objective here, to address a real condition. This is not a flexing of some sovereign muscle. And so I think with that, I would say in closing that we should commit to the dates we've set for next week. If it works out, it works out. If it doesn't, it doesn't. And then in terms of what we would need from the committee is a strong voice to the full legislature that this is what we need to stand for. And this process needs to work to accomplish the goals that was set unanimously by both chambers, saying that these tribes should enjoy the rights, privileges, and immunities of any other tribe in the country for their own success moving forward. And quite frankly, that success equates to success for our state as well. Better partnerships. Can we see a day where we're not fighting constantly about whether or not tribal members can fish in their indigenous waterways, that we work collectively with our state partners to form better coalitions, and there's no more skepticism, and there's nobody's saying it's not complicated. Even those states that have full sovereign statuses with their tribes, and of course there's complications, but that's when two sovereigns have to come together, work the tough issues and figure those things out. But so I think one of the representatives said it best. Do we have the political will or political stomach to be able to say, these are sovereign nations, everything that comes with that is what comes with it, and we all need to find a way to exist within those parameters. And so that's what I would hope the next week could bring. And again, I speak for me, I don't speak for the other chiefs, but I appreciate the question.
Representative Freckett.
Mr. Chair.
I'm sorry.
Sorry, Mr. Chair.
I was going to recognize Representative Record, who's had her hand up for quite a bit.
Yes, I understand that. I just wanted to
go ahead.
I had asked Chief Sabatis if she would also answer that question. So before we got to Representative Record, I just wanted to give Chief Sabatis an opportunity to answer that question if she so choose. Thank you.
I'll keep it brief. Yeah, I would ask the same. I think that committing to supporting us through this next week and whatever the dates are that we have scheduled for next week, so we can possibly, work some other things out in this bill would be really helpful. It would be horrible to get this far and cut us off at the knees if there's possibly a way for us to come to some agreement over the next week. And I'm trying to stay optimistic. So I guess that's about it. I'm going to stop there, but thank you again. And I think just supporting this process and not giving up on it or coming to the table, with a defeated attitude from the beginning next week, would be my request.
Thank you. Representative Freckett.
Well, this is one of those moments when you'd have no idea what you want to say. When the session started a year and a half ago, I started to dig even further into my limited knowledge around Native issues. And I would contend it wasn't as limited as a lot of people's, but it was still limited and still is. I attempted to read the American Indian law in a nutshell, and I'm not a lawyer, so this was a particularly difficult time. But what I did do was manage to read the sections on sovereignty and on lands, which really spoke to me about how different things are here in Maine. And I felt terrible about how different they are. I had been aware to some extent because although thanks to work with Representative Talbot Ross and Chief Maynard, and others, we managed to get the Violence Against Women Act stuff done this year. But I had been working with the judge for 4 to 6 years on that issue, and that's how long it took us to get to a place where we could actually do what needed to be done for Native women on this issue. And it terrifies me that we might be looking at 6 years on every little bit that we might want to get changed. I read almost everything I could put my hands on about the Settlement Act. I lived through that whole period in the state. I remember the hate. I remember the upheaval. It was a time when I wasn't proud to be a Mainer. Of course, nobody would think I was anyway, since I was born in Massachusetts, but I've been here for 50 years and I decided I would claim it. But I recently read through the paper that, oh God, her name, Maria Giroux wrote in 2012 about the land claims. And when I went to look at it a minute ago, I noticed on the cover I had written this thing, make sure you look at page 65. So I went back to see why it was I had underlined that. And it's because of a line talking about the land claims and talking about the tribes and the state. And the line says that the tribes in the state have fundamentally different views about the intent of the settlement. And I think we'd all agree on that probably. But the next sentence was the key one. Says the tribal view is unless we gave it up, we retain it. And the state's view is unless we gave it to you, you don't have it. And I think that's the crux to the problem. I mean, that's the reason that people are not getting it, that sovereignty is the key piece in this. And I see a move by this committee to, if it comes to that, and I suspect it will, to take a straight up or down vote on 29, whatever the heck the number is, of the bill, 2094. Take a straight up and down vote on that as a gesture that, for God's sakes, we at least, all of us who have spent so much time on sovereignty issues this year trying to understand and trying to do something to make it better. But I'm now of the belief that unless we get, as someone else said, Representative, Evangelo, I think, unless we get, or it might have been Chris Babbage, until we get to this critical piece, no, it was Representative Hartnett, I take that back, until we get to the critical question of whether or not we believe the Maine tribes should have sovereignty like the rest of the tribes in the nation, we're not going to get off at square one. And to me, if we come out of this next week with a vote that says, even if it's only unanimous amongst the Democrats and independents on this committee, but I think it won't be entirely that, frankly. I think that it's really important that we make a statement that we believe that this is unconscionable, that we've gone this long. I know all the reasons why things got screwed up this year. We thought they were going to get solved faster, but I'm not confident that we would have done any better if we'd all been here and healthy. And that's an indictment on me and the rest of the people like me who sit in our white comfort and don't make things different. And I'm sorry for that. And I do every damn thing I can. And I'd like to, I just got, my opponent just left the race. So I'll be back again next year. So I'm hoping that I won't have to retire without this issue being settled. It's important. It's critical, I think, to how we feel about ourselves as state and citizens of this state, and how the tribes feel about themselves and the citizens of the tribes feel about themselves. And I think that I think everybody in this Zoom, the dreaded Zoom, I think believe in the importance of and the integrity of everybody on this Zoom, and that we want to value all of our lives in a way that helps the state and us and the tribes and everybody move forward. So I'm appreciative of the work that everybody's done on this issue. I'm appreciative of getting to know more people than I did in the Native community than I did before we started this whole process. And I think that we will build on that. But if we pass this bill and it gets, vetoed or it doesn't pass the legislature, at least we have a piece that we can say, this is what we think is right. And if you want to come in next year and do a bill that's different than that, well, then, God damn it, get working on it right this minute, because we don't want to have it come up in February of the second year of the 130th. So I wish it would work, but I personally am committed to just say, for God's sakes, let's pass it. So I'll shut up.
Thank you, Representative Prickett. Others that have a thought or a comment before we decide how to move forward? Pardon? Oh, Representative DeVoe, I didn't see him back. Representative DeVoe. There you go, I got you now.
Thank you, Mr. Chair and Madam Chair. Apologize for not being 100% here all the time, but one of the things that I fear with what's going to happen is that this is going to be the typical kick the can down the road. And as a member of an indigenous tribe in New Brunswick, I've seen some of the problems with government relations with tribes, and working for the tribe over here in Maine, it was no different. And as a matter of fact, I find that Maine has treated the tribes even worse than Canada has. At least Canada has recognized some of the treaties that were written originally back over 200 years ago, where Maine only 40 some years ago decided to put this, I wouldn't even call it a treaty because it's a joke to me, this 40-year travesty to the bands forward, and has been living by this since then. It's just a complete travesty, and anyone who's had involvement in it had, to me, had their own reasons for it. I don't see I try to be optimistic about this. Like my fellow representative from South Portland, but I find it challenging in today's society and with the division of politics that it will actually happen. I don't know that I don't feel that there's a whole lot of interest in the parties to really make this difference. And I'd love for that to prove me wrong. I would love for the leadership to prove me wrong. I would like to see that this was actually be something that is actually looked at and dealt with. And if it takes a continuation by executive order, I'd love to see that, for the simple fact that it actually shows that the state of Maine is no longer treating the tribes as bastard stepchildren, but they're actually treating them as another sovereign. That to me is what should happen, and I'd be very upset to see the continuation of the state treating the tribes the way they have. And with that, I yield back. Thank you.
Thank you, Senator Bellows. We do have to move this shortly, though.
So I don't have any real comments. I mean, I think I concur with everything that has been said about the desire to move LD 2094 forward. That said, I heard Ms. Pisner say that criminal jurisdiction and taxation were two of the issues that were being discussed. And so I had a question about the criminal jurisdiction, because I do think that's really important from a sovereignty perspective. And I think the work that everyone did in signing a law to recognize the tribe's criminal jurisdiction over non-Indians for domestic violence crimes earlier this year over both reservation lands and over trust lands is really important. So one of the questions that I have for Ms. Pisner is the governor willing to do the same for Class C crimes, allowing for tribal jurisdiction or recognizing tribal jurisdiction on the reservation and trust lands? Because that was something that was in the amendment that we discussed in multiple work sessions, and it's just something that's really important to me.
Ms. Pisner, do you want to answer that?
I was trying to unmute again. I'm sorry, I'm not very technically adept. If it's a committee's wish that I respond, I'd be happy to. The piece of the criminal jurisdiction issue that maybe is not apparent on the face of the bill is that tribes in other jurisdictions where they are exercising the rights of other federally recognized Indian tribes that are sought after by the tribes in this bill, they don't do criminal prosecution above a certain level. They may do misdemeanor level. I'm not sure about that. I'm not an expert in this, but I do know that criminal jurisdiction on tribal lands is in major crimes under the Major Crimes Act. And Mr. Taub might be able to help me out here about the scope of that, is through the federal government. So if you had a Class C crime, for example, it would not be prosecuted by the tribe, it would be prosecuted by the federal government, which is why the decision that came out of Oklahoma recently, which said basically that that roughly half of Oklahoma, including Tulsa, were tribal lands for purposes of the Major Crimes Act, meant that the federal government, not the state, would be prosecuting those crimes. But they certainly weren't prosecuted by the tribes either. So what we're looking at here is sort of an experiment with, if you will, a step beyond what the other federal tribes have, federally recognized tribes have, which is the ability to directly conduct prosecutions of Class C crimes. The state would continue jurisdiction over classes A and B. So the concern about, you look puzzled that I'm maybe not explaining this very well.
No, what you just said, I think was contradicted at one of the hearings. I thought that tribes in other states absolutely prosecute more than misdemeanors. I don't know, perhaps Ms. Binney or Mr. Hinton have more direct knowledge of what's happening in other states. So that was where the puzzlement came, but I didn't mean to interrupt you.
It is. It's something that you might want to get clarified. I'm talking about, yes, the Class C. And I think the concern was that if you have only been prosecuting misdemeanor crimes and now Class Ds, when they involve the VAWA offenses, which again, we worked on that. Part of the problem with that was that, of course, the federal government, Congress, couldn't see their way through to approving that law again and funding it going forward. So we have a state VAWA law. I don't know if we're the only state that has it, but I'm not aware of another one that does. So just by way of saying how complex the interrelationships can be. So if you haven't prosecuted crimes that call for imprisonment of more than a year before, then that's quite a big step. And if you take out Title 17A and take a look at all the crimes that entails, that's a big bite. And so I guess the suggestion was that it would be better to start with, and maybe as a graduated process, start with the Class Cs on the reservation, and then maybe move to the territories later. That issue hasn't really been concluded. We have had discussions about it. So I don't know if that answers your question and you want to understand exactly what the Major Crimes Act jurisdiction is. I'm not the expert on that.
So, if I might, at this point, we have a little agreement. We have the potential for agreement on a couple of small pieces a week from today. We have a lot of frustration on the part of a lot of folks, and I haven't even given you my thoughts on that yet. Let's just stop for a second. So if we were to come back in next Friday or Thursday, and I would look to, I think one of the questions we had was Representative Talbot Ross. If you're listening, I know you are, there you are. Are you available Thursday and or Friday if we decide to come back in?
I will make sure. I will make sure to be, yeah.
Yes?
She said she would make sure, but ask her if she has a preference.
Do you have a preference? Okay.
No.
All right. Representative Harnett, you had a issue? Go ahead.
Thank you, Mr. Chair. I just noticed that when we were discussing criminal jurisdiction, it appeared that Attorney Hinton wanted to respond to. It appeared that Attorney Corey Hinton wanted to respond to Senator Bellows' issues.
I don't know that we've ever gone this long in one of these sessions without hearing from Mr. Hinton. So, did you have something you wanted to add, Mr. Hinton, on?
I would add something. To be honest, Ms. Pisner just shared information that hadn't been shared with the tribes before. She talked about a graduated approach to the restoration of our criminal jurisdiction. That's not something we discussed. When we were in this virtual room on Wednesday, we discussed positive progress. By the end of the day on Wednesday, I wouldn't have been able to share that same report with this Judiciary Committee. And we were told that we, the tribal attorneys, would be given more insight, some more fleshed out details from the governor's staff about criminal jurisdiction. What we've been told is that, yes, there's a preference that the tribe's jurisdiction not be extended onto tribal territory, which is entirely inconsistent with VAWA. Yes, we've been told that the state wished to retain jurisdiction, even on a concurrent basis, but nonetheless maintain jurisdiction over Class C victimless crimes. Those are 2 points that are contrary to the rules of federal Indian law. But we had hoped to hear more details yesterday from the governor's staff. And I specifically asked for those details in an email yesterday evening. And we actually just heard more details from Ms. Pisner that now the interest is in a graduated approach. Well, I really must say that it's a very paternalistic approach to be taken. The fact that LD 766 was enacted into law after hundreds of hours of work, and the fact that it allows for tribal jurisdiction over trust lands, and now we can't extend criminal jurisdiction beyond that. I want everyone to picture that they're in a house on trust lands away from the reservations, okay? And in the house, you have 3 people or 4 people, okay? You've got a domestic couple, and then you have friends. There's a fight between the domestic couple. Now, under LD 766, which is signed by the governor and enacted into law, the tribes have jurisdiction to prosecute crimes between those domestic partners, regardless of whether the perpetrator is Native American or not Native American. But if in the same house at the same time, there's another crime committed, a victimless crime or a crime committed against a Native American, ordinarily those are crimes elsewhere in Indian country that will be prosecuted by the tribal nation for which those lands are held in trust. Now, the proposal here would essentially provide for inconsistent application of criminal jurisdiction over tribal lands. It would very clearly create a dynamic where the tribes can exercise one level of jurisdiction on their reservations, but they cannot exercise that same level of jurisdiction elsewhere. If the goal of this is to avoid litigation and confusion, I would have to say that the proposal of the governor's office to split the baby this way, this surgical graduated approach of giving us a little bit now, maybe a little bit more later, it will only breed more confusion. And when we're talking about parts of rural Maine, the reality of this will be that there will be no criminal jurisdiction, and that law enforcement needs will not just be delegated to the state or to the local cops or to the tribal cops. No one's going to know who to call. And I will say that, you know, this entire dynamic that we're dealing with right now, this graduated approach, putting training wheels on tribal sovereignty, it's hurtful and it's offensive. Those details could have been shared with us in a meeting, but they were shared here after we expressly asked to be shared to receive those details prior to coming to the session. Instead, we were asked to come to this session willing to agree to continue dialogue, regardless of the tone and tenor and status of those negotiations. Now, my chiefs, the Beskid and Magadi Zagams, have authorized me to continue working because we want progress. But we are not here for breadcrumbs. We are not here for graduated steps to the recognition of our inherent rights. I was reminded by someone from the Longhouse the other day that sovereignty is not something granted to you, it's inherent. Now, our leaders signed the 1980 Settlement Act. There's no doubt. We're not here to play victim, but we're here to take care of our own and to take care of our lands, and graduated approaches are not going to restore this relationship to a government-to-government level. And we're here to continue that dialogue, but the way that this dialogue has been going, to be perfectly frank, is when we come to the table, we're told one thing, the next day we hear something else, or we don't hear anything, and then the next day we hear the next intel in a public setting. Now, I'm no legislative guru, I'm no strategic guru, but this approach to negotiations is purposefully being drawn out and is purposefully, seemingly attuned at ensuring that the tribes are not getting what they're asking for, which is at a minimum base level respect for our government to government relationship. And I'll stop there.
All right, thank you, Mr. Hinton. Representative Harnett, and then we're going to wrap up. Go ahead.
I'm done. Thank you, Mr. Chair.
Okay. So we need to move our committee process forward. And so here's what I'm going to suggest, is that we're going to meet next Thursday, 9 a.m. I'm going to ask the tribes and the Attorney General's office and the Governor's office to continue to meet. And we'll see where we are with regard to any discrete items that you've been working on, or that you may be able to work on between now and then. To Peggy and Sam, I do think there will be a need to have 2094 in a position where we can vote on it next Thursday. I'm extremely, when I came to the State House this morning, I was as optimistic as I had been at any time during the last year and a half. Representative Bailey and I started this process almost 2 years ago now, and I really was somewhat optimistic coming in today. As it turns out, that was misplaced optimism, apparently, and I'm sorry for that. But what I heard over the last couple of days suggests to me that we have made progress and we can get back to that progress. So next week, we will look at, and Representative Talbot Ross, I'll come to you in just a second. We'll get back to the items that you're working on. Hopefully, you will have agreement. I didn't want to have an up or down vote on 2904. At this point, we have no reason to believe the legislature is coming back into session before January, so it may be all a moot issue. I was fearful that a straight up or down vote on 2094 would blow up all of the hard work. And I look around at the board in front of me, and there's 1,000 hours. There's 1,000 hours worth of work up there between attorneys and representatives of the tribe and legislators and Paul Tebow and you name it. It just will really be sad if we blow up that which we have created. But next Thursday, we will take up the tribal bills, the 3 tribal bills. Hopefully you will have some language for us on some of the discrete items, and we'll end up probably voting on the balance of 2094 as well. Representative Talbot Ross.
Thank you, Mr. Chair. I don't have much to add. I just wanted to, before we ended today, wanted to recognize the good representative from the Passamaquoddy tribe, Representative Newell, and Ambassador Dana, and make sure that they were able to lend their voices, if they so choose, to today's discussions. Representative Newell or Ambassador Dana, I would yield my time to you.
I did recognize them earlier, but if they would like to add to the discussion, they're more than welcome to. No? Okay. Thank you. I thank Representative Newell for the use of her desk. Other questions or comments?
I actually will comment. I was
Sure.
deferring to Representative if she wanted to go first. So Representative, would you like to comment?
I was trying to unmute to defer to you, Ambassador Dana.
No, we're both too polite. I just wanted to really share my appreciation for everyone taking the time to work through this. I know it's very frustrating. I've been present for, I think, all of the task force meetings and a lot of the meetings on VAWA, and I've seen parties coming together, overcoming some great barriers and understanding. And I also fully support Chief Francis and Chief Sabatis and the strong words of Corey Hinton. And I would also like to add, when I gave my testimony initially, I reminded you all of the goodwill that it took to pass Indigenous Peoples Day and the ban on Indian mascots. And I also pushed you to think about sovereignty and what it means, and how we make meaningful, lasting changes. It's not a pat on the head, go be good little tribes now. It has to be deeper than that, or those changes don't mean much. So I'm really looking forward to continued collaboration, and I know that we're all in the midst of some hectic times, but I appreciate the leadership from everyone, and I'm really proud of our chiefs today for taking a real stand for tribal sovereignty. Thank you.
Thank you, Ambassador. Other comments or questions by members of the committee? If not, that will conclude our business for the day. Thank you all very much. I'll see you Thursday, 9 o'clock. Pardon?
You still have another bill.
That's right, too. We have the errors bill. I'm sorry. Peggy wasn't going to let me get away with that.
And I have a clarifying question. I didn't ask questions about collaboration in 2118 because I thought we were going to go to that next. Are we bundling those two in? Because I think I mentioned on Wednesday, I feel like that collaboration and consultation between the state and tribal entities is a really important process improvement to put in place to just advance the goals outlined so eloquently by Ambassador Dana.
I haven't had any indication from the parties that they have been talking about that. Maybe they have been, maybe they can between now and Thursday. those will be here, and we'll need a vote on Thursday on those as well. Those two bills. Thank you. Oh, I'm sorry, Representative, no, okay. That's all I have. Peggy, you want to talk about the errors bill? Of course you
I
do.
always want to talk about the errors bill.
That's right, your favorite toy.
Mike?
How many pieces do we have for the errors bill?
So we've tried to simplify this as much as possible. I usually like to make sure that somebody on the committee has seen absolutely everything we've done so they know exactly that this is clean as a whistle. And just to reiterate, I learned how to read the errors bill and look at what it was doing by working with Senator Carpenter when he was chair of the Judiciary Committee more years ago than we're going to.
Don't tell anybody how many years ago, Peggy.
Right, right. So instead, we're going to kind of do this abbreviated fashion. Anytime you have a question, you can stop me and Sam, and we'll say, we can kind of walk you through the issues. This, or the sections. This bill was probably the cleanest the easiest errors bill to understand. Most of the errors are conflicts. So a conflict is when usually it's two public law chapters amend the same section of statute differently. You can read them together, but the legislature hasn't taken either one into account when they passed the other. So most of this bill is correcting those conflicts. What I'd like to walk you through is, if you have your pink chart, you should have a stack of things. There's a pink chart, and then there's a big fat clipped thing, and it's 4 pieces of the errors bill and 3 supplements. And if you want to pull out your errors bill itself, it's LD 2169. It might be in a file labeled 3217, LR 3217. And we can take as much time as you want, but we can also go really quickly if you would like. So let me just walk you through the packets really quick. The one that says bill number 1 is all the sections that don't fall into these 3 other categories that are bill 2, bill 3, and bill 4. These aren't related to each other, and they're just correcting conflicts. For example, the very first section of the bill, there was a conflict created because the legislature changed what was Columbus Day to Indigenous Peoples Day. At the same time the legislature was doing that, the legislature passed a bill to make the statutes gender neutral, and they said, work through Title IV. At the very least, do Title IV. And so there was actually a reference in Title IV that referred to the Chief Justice in the masculine. And so Chapter 475 amended Title IV, Section 1051. These are court holidays, to change the he to the Chief Justice. At the same time, Chapter 59 was changing Columbus Day to Indigenous Peoples Day. And so you have a conflict. The way we fix a conflict is we repeal that unit of statute and reenact it with all the language from those conflicting chapters. So I'm not going to walk through every single section for you, but I do want to talk about bill number 2, the packet number 2.
Peggy?
Yes.
I just wanted to mention to the chairs, we need a quorum right through the end of this. Is that right?
You need to vote on this today.
That's what, and we need a quorum to vote.
Yes, you do.
So I'm just saying that so that everybody realizes
that
we need to
Are you telling me to speed up?
Thank you.
Representative Talbot Ross still with us?
She's not in the room, but she's here.
Okay.
We're going to lose Representative Bailey, however, in about an hour.
Okay, I don't need to take an hour, I don't think.
Good.
I just want to explain that packet number 2 is because the budget bill did 2 things. It changed what was the Governor's Office of Policy and Management to the Governor's Office of Policy, Innovation, and the Future. That was in Part D, and in Part III, it revised the focus of the Governor's Office of Policy and Management, and moved some of those functions like to DAFs or the state economist. They actually moved the stat economist, that's good. And so you had, in this case, 2 parts of the same bill amending the same statutes. And so what we're doing in this bill is making it consistent, except where the change in Part III was moving functions out of that office. We went with that version, the Part III version. So some of the personal income information is going to come from the state economist rather than the Office of Policy and Management or the Office of Policy Innovation in the Future. So I'm not going to go through every single section unless you want to. We're fixing the conflicts, but when it actually identifies duties of that office, we went with the Part III version. Bill number 3 is once again talking about the Governor's Office of Policy, Innovation, and the Future. So we're looking at the budget bill Part D, but there was another bill which ended up being Chapter 383, which made some changes and also changed the name from Governor's Office of Policy and Policy, Innovation, and the Future to, dropped off the Governor's, the Office of Policy, Innovation, and the Future. And so we're fixing those conflicts. And at the end of that packet as well, there are a couple of studies. Well, first of all, on page 6 of that packet, there's a revision clause that directs the reviser of statute to change anywhere it says Governor's Office of Policy and Management to Governor's Office of Policy, Innovation, and the Future. And we're changing that to be consistent with the new name of that agency, which is Office of Policy, Innovation, and the Future. So the reviser's office will be correcting it to the correct name, the new correct name. And changing a study that was passed in the first regular session to use the correct name of the Office of Policy, Innovation, in the Future rather than the Office of Policy and Management. And the last page of that section is a resolve that requires the committee, a study committee, to invite DAFs and the Bureau of Revenue Services and the Governor's Office or the Office of Policy Innovation in the Future to participate. So those are kind of a little bit different because they were kind of changes of the same thing at the same time. Number 4, and if I don't know if Sam wants to talk about this or I don't. Yeah, I don't know if if you remember, I'm just going to keep talking, Sam. I'm on a roll. You can jump in. Every time that there's a new criminal history record request that's based on fingerprints in the statutes, you have to look at it because you review it under the Freedom of Access law because there's a confidentiality provision that the federal laws require. So you will probably remember these. And what happens is we amend wherever that section is, the state auditor, DHHS, wherever, we amend those statutes, but we also go into Title 25 and amend the duties of the state police, who they take fingerprints of and what they do with that. And Sam, if you want to jump in, I really don't want to talk over you here.
Sure. So I think probably what will suffice for this is to say there's, when these 4 bills here, they did similar, there's a lot of conflicts. So basically what we did here was go through and resolve those conflicts while retaining the information in each of the bills. I don't know that it's necessary to go through each one. I think as Peggy said, it's pretty utilitarian.
I don't need it unless somebody else does. Thank you, Sam.
So, I mean, if you go back to the pink chart, you'll see that each one of the sections in the bill has a line. We've described what it is. We described that it's a conflict, and we think, or it's a name cross-reference, or it's punctuation in a series. We have a few of those. And you'll see that, first of all, the revisor's office doesn't put it in, they won't print it in the errors bill unless they think it's really a technical change. And a technical change means it doesn't change the effect of the law. We are fixing the law to make it read correctly so people understand what it is, but it's not changing the effect of the law. So all of these are technical. We don't see any reason to amend any of them. So if you have some time, I guess we'd like to look at the supplements that are in the back of your packet there. Is that okay? Keep going?
We're good. Keep going.
All right. Sam, I don't know if you want to talk about this one. It's a use of state vehicles for commuting.
Sure. So this one was actually sort of interesting, maybe more than some of the others. So this was some language. So there's language in 5 MRSA section 7 paragraph, or 7B, not paragraph B, that talks about when state employees can use state vehicles. And this section is about commuting from home to work. You're not supposed to do that. But then the section prior specifically talks about doing that, but they didn't cross-reference each other. So if you read them next to each other, you had no idea what the rule was. So this creates a cross-reference, adds notwithstanding language to make sure that they now work together, and also corrected some punctuation at the end that was a little bit ambiguous. This is something I think that's come up a couple of times as being an issue, and fixes it. And then supplement 2. So this has to do with, there's some language changes in LD 1867, which had to do with lobbyist reporting, and it changed references to the term indirect lobbying. It changed that term to grassroots lobbying, but that language needed to be carried through all the way into another section where it didn't quite make it under definition of original source, which also has to do with indirect or grassroots lobbying. So this is just making sure that that definition is consistent and we're not using 2 different terms for the same thing in statute.
Anybody have any questions?
So just to point out that the Veterans and Legal Affairs Committee identified this problem and they were hoping it could be resolved. It wasn't. The last couple of pages on this packet are a memo from the chairs of the Veterans and Legal Affairs Committee asking you to make these changes. The 2 bills that create, they're public law chapters, 587 and 599, actually don't go into effect until December 20th of this year. And so we need, you'll see on page 2 of this packet, we need an effective date of December 1, 2020 to make these changes consistent. Otherwise, we're amending something that's not quite there yet.
And the last one before we lose my co-chair.
Right. So this one has come to us through the Education Committee. It's kind of hard to see what happened, but it's about vaccinations. It is not about children. It is about employees in healthcare facilities. And in putting together the bill last year, they staggered some effective dates. They had some parts of their bill go into effect 90 days after adjournment. And then some of the changes wouldn't go into effect until September 1st, 2021. And then if you remember, this was the subject of a people's veto. And that was voted in March, and the declaration was made, I believe, the outcome of that election was made the end of March. So the effective date of Chapter 154 is actually April 20th, 2020. So to kind of explain what happened, if you look at page 7 of this packet, this is the chaptered law, Chapter 154. This is what went into effect. So what I boxed is number 1, Section 8. This is employees of certain healthcare facilities. By amending paragraph A, it expanded who could sign the statement that said the employee could have an exemption against immunization. And it's for it was medically inadvisable. Right now, it was prior to this bill, it was just a physician's written statement, and this expanded it to other healthcare providers could sign that statement. So that's amending Title 22, Section 802, subsection 4B, paragraph A. That was intended to go into effect with the rest of the bill, normal time. But if you look down in the effective date section, that actually was delayed to September 1st, 2021. And that was not intended to happen. What was really intended to happen was the repeal of paragraph B, which read, and you can go back and look at page 4, a religious or philosophical exemption is available to an employee who states in writing a sincere religious or philosophical belief that is contrary to the immunization requirement of this subchapter. That was supposed to stay into effect until September 1, 2021. So we just got mixed up in which one was supposed to take effect right away or in the normal course of legislation, and which one wouldn't take effect until September 1st of 2021. So the last the last page of this page, 2 pages, is a memo is a letter from the chairs of the Education Committee asking you to make the changes that show up on page 3 of this packet. And what this does is it reenacts that language about a religious or philosophical exemption as a new B1, because we can't go back to B, it's gone, it was repealed, and put in its own repeal date of September 1st, 2021. That fixes that religious and philosophical exemption for healthcare facility employees. That's the only people we're applying this to. And then the next piece, it amends that effective date section in Chapter 154 to strike out the reference to Section 802, subsection 4B, paragraph A. So that's the expansion of who can sign the medically inadvisable letter that an employee of certain healthcare facilities needs to avoid it, so they don't have aren't required to have a vaccination. And Section 3 of this packet makes that effective date change retroactive to April 20th, 2020, which was the effective date of Chapter 154.
Does anybody have any questions of either Peggy or Sam? I'm going to, if not, I would ask the people who are remote to join us, please. We're going to lose our quorum here by Representative Bailey in just a moment. So I would like to get a vote on this. I don't want to rush anybody. I don't think there's anything of substance here that we have to be concerned about. I haven't seen anything. If you can come down here, Representative Ross, Talbot Ross, Representative Babbage, Senator Bellows, we can get a vote on this and be done.
So just to be double clear, this is a substantive change. What supplement 3 proposes is a substantive change. I think what Veterans and Legal Affairs Committee proposed, you could argue that it's substantive a little bit, one of those sections. But it makes sense, it's consistent, but I think it might be changing the law a little bit. But it makes sense to make those changes that VLA is recommending.
This was a matter the entire VLA committee took up?
I think that they had been aware of it during the session before you adjourned, and they were hoping for another vehicle to fix it. And they're thinking that there's no other vehicle to do that.
Thank you. Two out of three.
And I do have to say that there's at least one more section that I've been approached to talk about, which was an amendment about the funding of the Civil Legal Services Fund, and I don't have that information yet. That would be, I think they might have touched base with one or both of the chairs. I've explained that it was something that was included in a budget bill, so the Appropriations Committee would need to kind of look at that because it would be a substantive change. And so we don't have those pieces yet. My understanding is that if that happens, you could review it, and if you approve it, it could be added as a floor amendment.
Okay.
If not included in this amendment.
Oh, Rachel's here. All right, I believe we have a quorum assembled in the chamber. I'm looking for a motion on the errors bill. Ought to pass by Representative Bailey, seconded by Representative Harnett. Are there discussions?
Was that an ought to pass as amended to include
Yes.
the supplements? Okay.
Yes. Representative Babbage? What? Oh, yes, absolutely. Further discussion on the errors bill. Motion is ought to pass as amended. Supi, would you call the roll?
Yes, absolutely. Representative Cardone. Representative Cardone is absent. Representative Harnett.
Yes.
Representative Harnett, yes. Votes yes, excuse me. Representative Evangelos.
Yes, and thanks, Peggy.
Representative Evangelos votes yes. Representative Curtis. Representative Curtis is absent. Representative Reckett. Representative Reckett is absent. Senator Bellows.
Yes.
Senator Bellows votes yes. Senator Carpenter.
Yes.
Senator Carpenter votes yes. Representative Bailey.
Yes.
Representative Bailey votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Talbot Ross.
Yes.
Representative Talbot Ross votes yes. Representative DeVoe. Representative DeVoe is absent. Senator Keim. Senator Keim is absent. Representative Hagan. Representative Hagan is absent. 7 members voting in the affirmative.
7 members voting in the affirmative, no members voting in the negative. It's the vote of the committee ought to pass as amended. Members of the committee who are remote, Representative Reckett, Representative Cardone, Representative Hagan, Representative DeVoe, and Senator Keim. If you're listening, you have 24 hours. With that, we will conclude the day's.
Thank you. I really appreciate your patience with this.
Peggy also, thank you so much. And Sam, you guys are great. Really appreciate all your work.
Thank you for having to leave, Donna.
Just wait till next year.
Oh, well, we skipped language review.
Oh, so you do have a pile on your desk that's green. I will scan those and email those out. And I know that some of you like to have paper copies, so that's why they're there for you. And I will send those out, and there'll be a few more coming for you to review. They're amendment reviews, and you need to get back to me if there are any issues with them. Bye. Thanks.